Good morning all. We're here for a hearing in the matter of CFI-015-2019 before His Excellency Justice Ali Madhani. The claimant is the litigant in person, Mr. Musaab Abdelsalam. The defendant is represented by Emirates Legal. The lead counsel is Sayyid Hussein Mujtaba.
Assalamu alaikum. Good morning all. Well, Mr. Musaab around?
Assalamu alaikum. No.
You speak English, Musaab?
Yes, of course, yes.
Okay, you're an English citizen, I guess.
Yes, I'm a citizen.
Would you introduce the team with you? Are you a lawyer or are you leading lawyer or what is?
No,
How
the
to
claimant.
I don't understand.
Yeah, he is the claimant actually. We are Ahmad bin Dhahi law firm. We register as in bar 1 only. So as we are not registered in bar 2 and Mr. Ahmad bin Dhahi actually he's out in the country for emergency. He's registered in bar 2 actually, but he's out of the country right now for emergency. He's in Saudi Arabia. So we would like to just, if Mr. Musaab can represent his case by himself, please.
Well,
And he is ready for this actually.
So you're an observer only today?
Yes.
Thank you. And Expresso?
Your Honor, we are the respondents in the instant proceedings. I will be the lead counsel in the matter.
And your team?
I have with me Ms. Rachel, our senior associate, and Ms. Nivedita, our associate.
So as a matter of housekeeping, we do have two different applications today. We have application to amend the claim form submitted by the claimant, and we have the application for immediate judgment to strike out the case for three different grounds. Is that right?
That's correct.
For unfounded provision of law, for time barred, and what's the third one?
Your Honor, if you permit me, should we, just for housekeeping issues, I was thinking
Yes.
it would be more appropriate if we would first present to the court the immediate judgment application, because that is the basis for today's hearing. And in the process, because I feel there are certain, what I would do to assist the court rather, is to take you through some very key paragraphs. I will only indicate the paragraphs to Your Honor, to give Your Honor a broader perspective of the context in which this immediate judgment application has been filed. Now, Your Honor will appreciate that why we have filed this immediate judgment application to broadly categorize the grounds. The grounds are very clear. First ground, it has been filed on the basis of the law that did not come into force at that time. At the time it was filed, and the opposite party, the claimant rather, admitted that fact, and they said at a subsequent stage, after the immediate judgment application was filed, that they should be given the leave to amend, and they moved an application in that regard. Even if this court were to find that there are grounds on the basis of which they should be allowed to amend their claim, of course subject to the rules and regulations of this honorable court, the point that becomes very relevant for determination by this court is, unfortunately, the claimant is not an employee within the meaning of Article 4 of the employment law, which was applicable at that time. And Your Honor, the third point is, even if Your Honor finds that the concerned person is an employee within the meaning of Article 4, then we have to look into the claims that have been set forth in the claim form, or it will be set forth in the amended claim form, for the court to decide whether these claims are barred by limitation. Now, Your Honor, clearly the DRC employment law does not anywhere mention the limitation period. And for that purpose, we refer to Article 38 of the DRC Code law, and then we look at the limitation period as 6 years. Also, Your Honor will notice that there is also a claim for damages and other things under law of damages and remedies. Again, if we look into the relevant provision, Article 22 of that law, it says the time period is 6 years. What we are dealing with here is not one contract, but a set of three contracts. And those three contracts, the commencement date and the conclusion date. The commencement date is all very clearly written and acknowledged by the other party. So, Your Honor, if limitation also acts as a bar, then unfortunately there is no other ground on the basis of which this claim will succeed. It is precisely for this reason we moved an application for immediate judgment under RDC 24.1, and we want to demonstrate the court today through references, through evidence, that the claimant has no real prospect of succeeding on the claim. And we will also demonstrate to the court that the defendant can successfully defend itself, and there is no other compelling reason why this case should be referred to the court.
So I
Your
see,
Honor,
Mr. Hussein, so in your opinion, the correct order is that you start by addressing your application, and you're going to touch open the claimant application for amendment by way or another, so then he can defend the both applications at one time and present his case. Okay. Actually, I have not seen the claimant reply or contest to the immediate judgment application. I might miss that. There is have there been one?
There is an objection actually.
there is a reply, Your Honor, which they have submitted,
Then tell me this morning.
which is known as, it is in fact, it is the claimant's rejoinder to the immediate judgment application, that is volume 6, volume 1, tab 6. In fact, this is exactly what I wanted to take this one to go through first. Volume 1, tab 6, page 99 onwards, running page 99.
I see.
So, Your Honor, there is a reply, and I want to take this quote through that reply.
I honestly have missed seeing this one in particular.
So, Your Honor,
But you have not addressed this, Mr. Shuaib, in your skeleton argument, isn't it? The reply for immediate judgment application.
We have replied to that
In your skeleton argument,
in the skeleton argument as well. We'll find that.
I have one skeleton argument addressing the matter of your amendment application.
they have mentioned, Your Honor, in this skeleton.
Yes.
If I may assist the court. In this skeleton, Your Honor, which is filed by the claimant on immediate judgment application, considering that there are two skeletons, so we should look at the skeleton which is on immediate judgment application. Your Honor, this skeleton was filed on 24th of September 2019.
Who prepared this bundle? Is it you, Mr. Hussein, or the claimant? Who prepared the bundle before court? Is it you or the claimant?
Well, there are two bundles actually, Your Honor. So we'll coordinate it together for that. There are two bundles.
Yeah, I know. There used to be a very short, small bundle.
Okay. Yeah.
That is the claimant's.
That's
This
the
for
claimant.
our application for amendment.
And then I have received this one.
That is ours, Your Honor.
Yeah, this is for them actually.
There are two volumes, so let me just, for housekeeping, if I may just assist the court with the documents that we have on record. Your Honor, there will be 3 bundles actually.
So tell me, where can I find the claimant skeleton argument for the immediate judgment application? Where it
That
is?
was filed separately, Your Honor.
What do you mean? It's not in the file? It's not in the bundle?
It is, unfortunately, it was prepared, submitted later. It's not part of the bundle. If you look into the files, it's not there.
Yeah. No, it's okay. We can just say.
Maybe? Opinion? Yes, this one. Very good, thanks. And now I think I have all I need as submission. So no, Mr. Hussain, I think I would agree to your order. I will ask you to start first. So he will address his immediate judgment application, and he will take me through your application as well, Mr. Shab. And until Mr. Hussain finish, you may remain seated.
Thank you. Thank you.
Your Honor, with your permission, just for housekeeping, so that because I will be making a reference to documents, the respondent has prepared the documents for immediate judgment application. In this regard, Your Honor will file 3 sets of these files. One will be titled as Volume 1,
Yes.
and which I will be referring to more often. And there will be Volume 2, which will also contain, which will be referred to as case bundles, / the references. And then we have an authorities bundle, Your Honor. In the authorities bundle, we have the relevant laws and some relevant judgments. Your Honor, I may also request the Honorable Court, since our respondent's skeleton was filed separately, if Your Honor has a copy of the respondent's skeleton argument on the immediate judgment application in present in front of you.
I do have it. I've read them.
Yes, Your Honor. Your Honor, I don't want to take the time of this court. We have, if you turn to page 25 of my skeleton, Your Honor will see
Page 25?
Yes, Your Honor, which is known as Schedule A.
Which skeleton are you referring to? The immediate judgment?
Immediate judgment. Yes, Your Honor.
Page 25. Yes, I'm in page 25. The schedule?
Yes,
schedule
sir.
A?
So there is a procedural history and
Oh,
timeline
yes,
of events. So we just set out below from the beginning to the end for this honorable court at its convenience if there is any reference at any time that is needed. So we will be referring to this schedule, Your Honor.
Yes.
And Your Honor, last but not the least, I want to drive you, since you're on this page, on this schedule itself, if you go to page number 34, which is Schedule C.
The paper about the application of employment law?
Yes, Your Honor, retrospective application. Now, Your Honor, why we have referred to this is because we are duty bound to bring to the attention of the Honorable Court that there is that law number 2 of 2019, the new employment law, has retrospective application. So what we did, Your Honor, was we analyzed this particular law in relation to the facts of our case and saw if a different conclusion or a same conclusion would arrive at, and I respectfully submit, as I would argue towards the end of my submission on immediate judgment application, that under this law there is clause 10 and article 10, and article 10 brings in a limitation of 6 months, and there's a whole history of why the lawmakers thought to reduce this period to 6 months by virtue of penalty under article 18. So that is a separate question and not for discussion, but we thought we should bring to the attention of this honorable court. That's why we appended it as a schedule. Should the court find this necessary, the court may be able to look at our submissions in this regard. Now, Your Honor, let us first understand what is this case all about. On 20th of March 2019, a claim form was filed in the honorable court. I'll take you through it now. Then, Your Honor, on 5th of May, the particulars of the claim were filed. Now, in this regard, Your Honor, I think it would be good if we could just make a reference to the particulars of claim, since we have to deal with 2 applications. So if Your Honor sees the particulars of claims now, it will help in the subsequent application. So, Your Honor, I'm referring to Volume 1
Yes.
of the CC and tab 9. And page that I'm referring to is 126, because first is the claim form, and there's not much written there.
Yes.
But I think what we need to refer to is the memorandum accompanying the claim form. Now, Your Honor, at page 126, this is a claim where they say that it is arising out of contractual obligations to the claimant pursuant to employment agreements. So the word used is employment agreements,
Right.
entered into between claimant and the defendant, and the failure to adequately compensate the claimant during instances of such breaches and deprivation of labor rights of the claimant. So there are three things here. First is breach of contractual obligations. Second is pre-employment agreements. And this has led to the deprivation of labor rights of the claimant. Now, Your Honor, may turn to page 127. At page 127, I would request the Honorable Court to refer to paragraph 4 of the submission. And the important point here is, I would like to read the relevant part of the paragraph. The claimant has been employed by ETG, which is us, since 2008 in various roles pertaining to the terms and conditions, etc., etc. And then, fifth line, as part of the same employment for fixed terms. In other words, pursuant to employment agreement number 1, so they're referring to employment agreement number 1, the claimant had joined ETG as their networks planning operations director since 1st November 2008 for a monthly remuneration of so and so for a fixed term of 2 years, concluding on 31st August 2010. So this is the first contract that commenced on 1st November 2008 and concluded on 31st August 2010. And it says, before the expiration of the employment agreement 1, as per subsequent, so there was a second employment agreement number 2, that was entered into between claimant and defendant, which is effective as on 1st August 2010 for a fixed term of 2 years and concluded on 31st July 2012. And then if you go down below, it talks about the third employment agreement. And they say that it was effective on 1st August 2012 and ended on 31st July 2014. Now what I want to bring, I am referring only to their submissions, Your Honor, to bring a very critical point to the attention of the Honorable Court. They are arguing that this is an employment contract. They are saying there are 3 employment agreements. So each of these employment agreements has a date on which it commenced and it has a date on which it expired. And then there is a subsequent employment agreement. The word used is it's for a fixed term, but it's not for an indefinite period. So therefore, Your Honor, the only reason I'm pointing this out at this stage is for this Honorable Court to note that the expiry date of this contract shall be relevant in computing the period of limitation. Your Honor, if you read paragraph 5, last 2 lines on the same page.
That's because you want to argue that there is no continuous employment relationship.
That is one of the arguments, Your Honor. Yes. And the second argument also, which I will bring to the attention of this court very shortly, is how it is a consultancy agreement and not an employment agreement. So that is, in fact, the key argument which I will bring to the attention of the court.
Yes.
Relying on the documents which are in evidence and are form part of the record. But for the moment, I wanted to bring to the attention of this court these 3 employment agreements. And Your Honor, on the same page 127, if you look into the last 2 lines on the page, it says the claimant has received his employee or labor rights as per the provisions of the employment agreement between the claimant. And if Your Honor may turn to the next page. And the provisions of the DIFC Employment Law number 4 of 2005. Now they're referring to amended as law number 6 of 2018. Now law number 6 of 2018, this is a regulatory law, this is not the employment law. But I just wanted to bring to the attention the grounds on the basis of which the case has been filed.
That's what he said, it's a mistake.
Your Honor, that is the point of the example. Absolutely, Your Honor, that is the point. If it's a mistake, then I will demonstrate to this Honorable Court why it is not a mistake. Why they rely on the provisions of the draft law and not on the provisions of the current employment law. And of course, they have themselves.
You just said this is not reference even to the draft law, isn't it? You just said amended as law number 6 2018. This is not the correct reference to the draft law of employment, isn't it?
Your Honor, the draft law of employment is law number 2, now as law number 2 of 2019. But I will just show you.
Well, that means they're not referring to the new amended law of 2018.
They're not referring to. Your Honor, what I wanted to come, I just wanted to give you an indication of the paragraphs there.
Give me whatever you want.
If we go into what they have claimed, because we have to go by the substance of what they have claimed, which I'm coming to on page 138. If you move to page number 138, Your Honor, of the same submission,
Yes.
I will answer this question. This question is very clearly answered. Now, Your Honor, what relief they have asked from the court, it starts as, and the claimant claims, declaration that the defendant has breached the contractual obligations that he owed to the claimant pursuant to the provisions relating to remuneration, term of appointment, notice to terminate employee service, resignation, end of service, gratuity, etc., etc. And number 2, breached and contravened provisions of law under Articles 18, 19, 64 and 65 of DIFC Employment Law number 4 of 2005. Now, Your Honor, there is no 64 and 65 in the DIFC Employment Law number 4 in the current employment law. It ends at Article 62. So there is no Article 64 and 65. And Your Honor, if we go slightly up, as paragraph 17 on the same page, it says, the defendant is therefore entitled, therefore is in breach of his contractual obligations pertaining to the provisions relating to remuneration, term of appointment, end of service, so and so, to terminate employee service or resignation, and in default of Articles 18, 19, 64 and 65 of Employment Law number 4 of 2005, Employment Law number 6. In addition to that, they are asking for damages and other things. Now, Your Honor, this is, if you go into the relief which they are asking on the next page, page 139, this is the relief clause which they are asking. And if I want to bring your attention to clause F, the defendant acting in contravention be made liable for fines and penalties as per Schedule 3 of DIFC Employment Law number 4 of 2005, amended as Law number 6 of 2018. Your Honor, there is no Schedule 3 in Law number 12. If it was merely a typographical error, why would a party rely on the provisions of the, and I shall demonstrate to you how these are the provisions of the draft law, and then say that it was a mere grammatical error? Then Article 64, Article 65, and Schedule 3 would not spring into the picture. And I will show you from, I have demonstrate to you through what they have written. I'm only going through their submissions rather than mine, to drive home the points that I wish to convey to the Supreme Court. So, Your Honor, this was the claim form. Now, Your Honor, on the same volume, if Your Honor will be kind enough to refer to tab 10, and tab 10 is the statement of defense which we have filed. This is volume 1, tab 10. Now, Your Honor, this is the statement of defense which we have filed to their statement of claim. Now, Your Honor, in the very first instance, let me just read out a few important.
Sorry, what are you reading? Tab 13?
Tab 10, Your Honor. Tab 10, the statement of defense.
Yes.
At page 191. Your Honor has the claim, the form in front of it. Your Honor, we have raised, if I may just touch upon the points and not read the points in their entirety, let me give you the grounds. This is our statement of defense, and we have raised certain objections here with regard to the maintainability of this claim. And we have said at line 3, point number 1, the claimant has based his claim on 2018 amendment to the DIFC Employment Law, which is yet to be enacted as a law and currently exists as a draft. Therefore, Articles 18, 19, 64 and 65 of the draft law that have been relied upon by the claimant do not have the force of law. The claimant cannot seek relief on the basis of a law that has not yet come into force. Your Honor, after all, the issue is whether a cause of action has arisen pursuant to the provisions of the law. Now, this is our first ground The second ground in our statement of defense, Your Honor, is point number 2. The employment law currently prevalent in the DIFC is the DIFC law number 4 of 2005, amended by employment law number 3 of 2012, which was the employment law. At the time we filed our statement of defense, the defendant submits that even if the claimant had filed its claim under the correct law, it would not be applicable to the facts of the instant case. And the reason we have given is because Article 4 states that this law shall only apply to an employee of an establishment having a place of business within the DIFC and where the employee is based within or ordinarily works within or from the DIFC. We shall demonstrate this to you below, how he is not an employee. And if you turn to the next page, page 192, we have written at the top of this, the claimant was in fact employed by another company in Sudan during the same time period, details of which were not disclosed to the court.
Is it 192?
Page 192, the next page, the very next page, Your Honor. Your Honor has found it?
Yes.
Your Honor, it starts with the claimant was in fact employed by another company in Sudan during the same time period, details of which were not disclosed to the court. The details of this employment have been discussed below. So we have to look into our ground 4 is failure to make a proper disclosure to the court. Failure to disclose to the court that the time period for which he is seeking relief in this court through an application that has been made pertains to the period for which the claimant was employed in Sudan. And we have evidence also. Now, how do we prove this point? I will just take you through the evidence now to prove this point. And my sixth ground is that even if he's treated as an employee, and even if court were to ignore all the submissions that we have made previously, then limitation acts as a bar insofar as claim number 1 and claim number 2 is concerned. And Your Honor, last but not the least, my seventh ground is, if you look into the claim form and if you look into the subsequent memorandum accompanying the claim form, Your Honor will notice that there is only reference to provisions like Article 18, Article so-and-so, Article so-and-so. What has not been explained, Your Honor, is the content of those articles, how the elements of those articles. Those articles have not been applied to the facts of the case to establish a breach. So the pleadings are quite vague, and we found it extremely difficult to prepare a response. And Your Honor, if you look into the violations of damages and remedies that they are seeking, they are referring to the articles of law of damages and remedies, but they have not argued how the elements of those laws are satisfied. They have not produced the evidence to demonstrate how and why this is paid. With the permission of the Honorable Court, may I now take you to on the same statement of defense. Now, Your Honor, I would request you to turn to page 200. This is extremely critical.
Yes, I mean.
Page 200. At last paragraph is paragraph 3.2.6. Your Honor, before this is 3.2.5, I don't want to argue on 3.2.5 because Your Honor has already dealt with several and even several judgments on these issues. What does it mean within and outside DIFC? But I want to first comment on 3.2.6. Your Honor, with your permission.
I am going.
The defendant submits that the claimant was never in the DIFC during his entire employment under the 3 employment agreements. When the claimant was offered the first agreement, that is in November 2008, he was working in Sudan with another company by the name Zan Sudan. Pursuant to a non-compete clause in the employment of Zan Sudan, the claimant was not allowed to work with a comparator for a period of 6 months from the date of termination. Now, Your Honor, 3.2.7, next paragraph. Thereafter, the claimant was relocated to Sudatel in September 2009 when he entered into an employment contract with Sudatel. Now, Your Honor, the most important point which I will demonstrate below is, even if you look into the claims, which I will take this Honorable Court through, they are saying relocation allowance, which means the claimant is asking for relocation from Dubai to Sudan. So if you ask for relocation allowance, if part of your claim is relocation, and if you're claiming relocation from Dubai to Sudan, in such an event, how can you say that you were within DIFC or you were working from DIFC?
But why you are using the word asked? Your statement of defense doesn't say he asked. You said he was relocated. It didn't say he asked to be relocated.
No, he was. Your Honor, he did not ask.
This
to
is
be
your
relocated.
statement of defense, isn't it? We're reading your defense, isn't it? Or
Yes, this is our defense, Your Honor.
okay. So it said the
I-
claimant
I-
was
I-
relocated.
he was relocated.
Didn't say he asked to be relocated.
He was relocated, Your Honor.
Yes.
So that I stand corrected, Your Honor.
Okay.
He was relocated, Your Honor, in September 2009, where he
Yes.
entered into an employment contract with Sudatel. Pursuant to this employment contract, the claimant was receiving a monthly salary from Sudatel. The employment with Sudatel continued till 2017, when he was terminated for absence without notice. The claimant was therefore never physically present in DIFC during the entire claim period, that is from November 2008 until July 2014. He was present in Sudan, working for a Sudanese company, subject to Sudan labor law, and was receiving a salary for this employment. This fact is confirmed by the fact that the claimant has filed a claim against the relevant Sudanese companies claiming similar claims. Now, Your Honor, I would like to pause at this statement. I want to bring to the attention of Honorable Court the annexure number 5, which is at page annexure number 5 is at page 271. So
271.
200, page number 271 of the statement of defense, the same statement of defense that we are having in front of us, Your Honor.
Statement of account.
Your Honor, this confirms that he was receiving salary in Sudatel,
Yeah.
and the time period for which he was receiving the salary in Sudatel is also mentioned therein. So I wanted to bring this relevant annexure to the attention of this Honorable Court. And if Your Honor may then move to page number 276, 277
Claim form.
of the same
Yeah.
statement of defense, which is
Yeah.
annexure number 6.
I see.
Your Honor, I will, with your permission, read page 278, which is the translation. But since Your Honor is familiar with Arabic, so Your Honor can see at page 276 and page 277 in Arabic. It is this is the claim which they have filed there, and it is written. They have made an application there, and in that application, at paragraph 1, they say that my agent, the claimant, was working with the defendant since September 2008 up to May 2017, and the last monthly salary for him was so and so, plus US $5,000. The last position held by my agent with the defendant was so and so, director planning. And then on third point, on 20th September 2016, the defendant sent my agent, the claimant, in a work trip to UAE, so and so. Then next point, the UAE authorities stopped my agent at the airport, so and so. And on point number 5, on 8 May 2017, defendant has arbitrated. So there is a claim, Your Honor. There is a claim which they have filed in Sudan before a court, which pertains to the same time period of their employment, which forms the subject matter of this submission. I just wanted to bring these 3 relevant annexures to the attention of this Honorable Court. Now, may I request this Honorable Court to go back to my submission at page 201. When I had paused at paragraph 3.2.7, and if I may go back to that paragraph with your permission, Your Honor. Page 201.
Yes.
Your Honor, if you read the last 5 lines from the bottom of the paragraph 3.2.7, the fact of his relocation and employment in Sudatel is a central issue to many of the claimant's claims. This fact was concealed from the court, as the claimant's only intention through this litigation is to make money. This fact was never brought to the notice of this court. A party is mandated and obliged to bring forth every fact in relation to this claim. And then paragraph 3.2.8, the claimant has effectively relinquished all his claims as an employee of the defendant when he accepted the employment at Subatel by signing the employment contract. The claimant even filed labor claim against Subatel in 2017 for his employment with them from 2008 until 2017. And then at paragraph 3.2.9, the claimant acted as a consultant for the defendant. And Your Honor, in this regard, the defendant shared a draft consultancy agreement with the claimant, which clearly demonstrated the fact that the claimant was a consultant as opposed to an employee. Clause 1 of the draft consultancy agreement made it very clear that the claimant would be engaged by the defendant as a consultant and not as an employee. However, the claimant refused to sign the agreement and the defendant had no option but to treat the first agreement as a consultancy agreement. Now, Your Honor, I want to bring to the attention of the Honorable.
What do you mean the claimant refused to sign?
We see a draft consultancy agreement.
No, if you refuse to sign, why you call it agreement in the first place?
Your Honor, the position of law is very, I think there are two ways of looking at it. I have this relevant consultancy agreement in case your Honor wants to have a look at it. It is in Exhibit 8.
No, explain to me, what is the argument first? Then I'll look at the document.
Yes, Your Honor. Yes, Your Honor. Your Honor, let me explain the relevance of issuing an employment agreement. Clearly, Your Honor, the concerned person, the claimant, could not have been engaged in Subatel for the same time period and in DIFC for the same time period. He was engaged in DIFC as a consultant and his services were used for those fixed term time periods during that term only for the purposes of his expertise in the particular field for which we needed him. And that is where we have argued in our statement of defense and in our skeleton and in our other submissions that he was never an employee of the DIFC. He may have a claim against the defendant, but his claim does not arise from the employment contract, because this is not merely because it is worded as an employment contract. But if you look into the plethora of evidence that is before the Honorable Court, it was never intended to be an employment contract, because it was never intended that the claimant would reside in UAE. Now, what did we do, Your Honor? We went a step further. In fact, if you will see in our submission, which I'll demonstrate to this court, we have analyzed the entire record from 2018 until now of when the claimant entered and left.
2008.
We have also submitted that as part of the record, and that is Schedule B to the skeleton arguments. Your Honor, may go back to my skeleton argument, the respondent's skeleton argument of immediate judgment application, which is separate. And if you look at Schedule B, Your Honor, okay, and this has been extracted from their documents, the flight details which they have provided. All we have done is we have compiled their information.
Who's they?
The claimant.
This is your own record, Mr. Hussain.
Yes, Your Honor, we have extracted it from the record which they have submitted.
This
And
is your own Excel sheet.
This is our own Excel sheet. We have. That's what I'm saying, Your Honor.
Doesn't say where the information comes from.
This has been. That's why I'm making this submission before.
You're not immigration. You're not at Dubai airport. I don't know based on what you have prepared this.
Your Honor, we have not taken, and we have submitted this document to the other party. We have not disputed it, Your Honor. They have not said that the information contained in this particular sheet is incorrect or any record that we have provided does not match. Because, Your Honor, I can show you. This is which volume? Volume. Your Honor, if I can show you the source of this. The source of this document is in volume 2. Their reply to the defense.
What is it?
Volume 2, Your Honor, page 388, tab 11, Your Honor.
This is Emirates tickets records.
Yeah, from there, here they have provided all the record, which we have compiled in the form of an Excel sheet. This is filed by the claimant, Your Honor.
Yeah, but these are flight to Dubai and from Dubai. I can't see, this is what I can see.
Your Honor, these are various flight details, and the reason why we are submitting, we have not submitted it. So rather, the reason why we are referring to it is because subsequently we are going to argue that Article 4 of the Employment Law.
No, excuse me. I mean, while we're still here, what this record showing? It's showing he traveled from Khartoum to Dubai and Dubai to Khartoum.
But he was never, if you look into the record that we prepared in our skeleton, if you analyze that record, Your Honor, you will see that it was not a permanent, he was not working out of DIFC.
So he was not working out of DFC?
He was not working within or from DIFC. He was working out of, as a consultant in Sudan, assisting our company from time to time, not as an employee, but as an independent contractor, as a consultant.
But this is, let me check this out. Let me go to the year 2012.
Your Honor, this is just for the reference of the court, Your Honor.
I think here, like the record shows, he came to Dubai to 27th of February. I don't know when he left Dubai, I'm not sure.
He kept coming and leaving. Your Honor, our record indicates, which we have extracted from it. And we confirmed to the court that we prepared it on the basis of what was provided there. It shows he was coming and going. And there were moments when he did not even came into the office, where he was changing a flight from the airport itself. Now, Your Honor, this is just why we have brought this particular lecture to the attention of the Honorable Court is for this Honorable Court to take note of the fact that it was not as if the employee was in Dubai. He was engaged in another company.
No, Mr. Hassan, you can't come, I mean, come make this kind of jump very fast. You want to show me evidence and you just want to take whatever you want from that evidence.
Your Honor,
without giving me the chance to understand what's the evidence all about.
Yes, Your Honor. We can go through that evidence, Your Honor.
Well, I'm trying to understand this.
Then, Your Honor, should also be kept in handy so that if you look into the number of, we have analyzed the number of days, the travel details, so all we have brought in one chart.
Okay, Mr. Singh, can you go to page 404?
Page 4.
404.
Yes, Your Honor.
You see this? This is the ticket reference in 2012.
Yes, Your Honor. 24/4/2012.
Can you help me reading this or help me understand this, how it works?
Can I ask my colleague to assist?
Yes, please.
Yes, Your Honor.
Yeah.
Your Honor, if you can look at the first row, the first column, that would be the date. And the second column would be the flight. The third column, sir, would be when the last line, 1, 2, 3, the fifth line, sir, where it says 30th of April 2012. So that is the date on which he flew from Khartoum to Dubai.
To Dubai. This is 30th of April.
Yes, exactly, sir.
And then he stayed in Dubai until
Yes,
the
he
23rd of April, isn't it?
Yes, sir. Before that, he
Well, we
left.
can see in the next one.
Yes, before that he
Well,
left
that's-
Dubai on 23rd of April 2012.
No, I think you should read it upside down.
Upside down, exactly. So you have to go from the bottom to the top. Right. So on 23rd of April 2012, he left Dubai, went to Khartoum. Then 30th of April 2012, he came back to Dubai. Then,
And
if you
then
go
when
to the
did he
next-
go to Khartoum again? 25th of May.
Sorry, sir? 19th of May. He went Khartoum again on 19th of May. Yeah, he went from Dubai to DUB, sir. That is, I think that's another part of the world. So he left Dubai on 19th of May. So all of this is, if you have a look at the Schedule B, Your Honor. Yeah, if you look at Schedule B, Your Honor, you just have to juxtapose this against Schedule B. So whatever is mentioned here, we've just taken it and put it in an easier way to understand. So the first column would be the date. So the first column serial number. This I'm reading from Schedule B now.
Yes.
Date. Then the travel details. We just put where he's travelled from and where he's travelled to. And the number of days indicates the days he stayed in Dubai. And also we don't know whether he's visited the...
Okay, let's stick to number one. Number
Yes.
one, he stayed 103 days in Dubai.
Yes, he stayed 103 days in Dubai. That is the first part. That is under in 2009. So totally...
See, the number of days showing here are the days he stayed in Dubai.
Exactly, yes, Your Honor.
Nothing to do with Khartoum days.
Nothing to do with cartoons. Everything is in Dubai. So this shows his...
So there is 171 day
Yes.
in 2009.
Exactly.
That make it almost half of the year.
half of the year. But
And
you
you
keep
say
going-
he didn't have a presence in Dubai.
No,
Let's go to the
and-
next year.
Yes. In 2010?
He got 151 days. No,
97.
97.
Yes. Yes, Your Honor.
And the year after, 151 days.
151 days, yes, Your Honor. Then 2011 is 193 days.
And Mr. Hussain said he didn't stay in Dubai at all.
He kept coming
Your
in.
Honor, if you will see that this is coming and going, Your Honor, the submission I'm trying to make is that he was
Okay, my question, when he comes to Dubai, does he work? When he in Dubai for 150, 170 days, 112 days, 36 days, and 79 days, did he work in Dubai or not?
He did not, as far as...
Well, he's in
sometimes-
holiday.
Sometimes... what
He's in
happened-
holiday basis, Mr. Hussain?
No, Your Honor.
What?
Sometimes he would come to office and sometimes he would not come to office.
Sometimes he comes to office doing what? Cleaning the office?
Your
But that's
Honor,
still work, isn't it?
Of course, Your Honor, for work.
Yes.
Of course, Your Honor. I mean, for the...
So he did some work in Dubai offices, isn't
I am sure, Your Honor, we are not disputing the fact. What we are not disputing is that he did some work.
No, I remember I heard you this morning. You said he didn't work and he didn't
Your
work
Honor,
from
he
Dubai.
did not work as an employee within the meaning of the employment law as is applicable in Dubai. He worked as a consultant. That is why I was driving home the argument that he worked. So I'm not disputing the fact
Then
that he did not work.
if you arguing he did work from Dubai in a consultancy basis and not from employment basis, why do we need this record? Why do we need all of this record?
Well, you see, the most important point is, Claimant has argued that Claimant is an employee within the meaning of the employment.
No, if you manage to convince me he's in a consultancy basis
What we are
and he
arguing-
worked part-time, that's enough. You didn't have to go through all of these things.
Your Honor, this record was submitted by the claimant itself. We wanted to show, to see that there was any continuity in the service. So we analyzed for the purposes of this honorable report the exact number of days.
So now you say he did work in Dubai for some times, but he was working based on consultancy basis.
Yes, Your Honor.
Okay.
And that did not require him to be
And
physically
he did not sign the consultancy contract. He refused to sign,
We provided him a draft consultancy.
and he refused to sign.
That is our submission. And Your Honor may also take note of another important point.
Yes, which
Which is that the the claimant has itself received money from the defendant for the period that he worked as a consultant. So it's not the issue, but what he's claiming now are the benefits which are being granted to an employee under the provisions of the employment law. So it's not as if we have not paid him any money in that regard. He has received his dues. But now what he's claiming, after this long period of time, from 2009 until now, is the employment benefits which are only given to an employee. So why we refer to this record, Your Honor, was only to demonstrate to the court that there was no relationship of an employer or employee between the two parties. And even if you were to refer to Article 4 of the employment law, it is very clear that the required elements are not satisfied. So it is only
Employment law, no, 2012?
Of 2012, yes, Your Honor.
Is that applicable law to the matter or the one before?
Your Honor, it was before. It was at the time we filed our statement of defense. And it is still applicable. It has not been repealed. That particular provision still stands in its original form
That's
in the
it.
new law.
Yeah.
So that is not been repealed. Your Honor, if you permit me, I have just one more paragraph. Is it possible for me to take this on the report?
Yeah, sure.
Your Honor, on the same statement of defense, which is volume 1, tab 10, page 206.
206, yes. I'm in there. Yeah. Yes, Mr. Singh?
Yes, sir. So I don't want to read it, but I just want to bring it to the attention of the court, paragraph number 4.
Even if you want to read it, you are allowed to do that. It's you're still within your timing, Mr. Hussain.
Thank you.
I shall give you your full right of defense.
Thank you. Thank you. Your Honor, in this, actually, because I just want to avoid the repetition, but here again, we have stated that the defendant refers to the employment contract dated 1st September 2009, which was signed between Claimant and Sudatel. Under the Sudatel employment contract, the Claimant was given position of planning division manager and was drawing a salary of so and so. Evidence of the salaries being paid can be seen from the account statements of Sudatel, wherein it specifically evidences the monthly remittance of SDG. Now this is of 5923. Now this is financial file which you have seen.
I didn't see this. What you're reading in 206?
4.3.5, Your Honor, page 206, paragraph 4.3.5. Second last paragraph.
Yes. I got it. Yeah.
Yes. And then, Your Honor, the paragraph below it, 4.3.6. After the claimant was relocated to Sudatel in Sudan, the defendant intended on retaining the services of the claimant as a consultant for the defendant. In this regard, a draft consultancy agreement was shared with the claimant, which I read out to you. Now, Your Honor, this is from this moment, I want to bring to your attention another document, which is their reply, which is the first document that is Honorable Court referred to when we started our proceedings. On the claimant's answer to our statement of defense, their rejoinder to our statement of defense, which is volume 2, tab 11. Volume 2, tab 11.
Page number?
At page, Your Honor,
Yes.
page 300.
Yes.
Where is my volume? I'm sorry, Your Honor, I marked it in front of you. What you said.
Take your time.
Your Honor, this is their reply. Now, this is reply to the statement of defense. I feel this reply is very important also. At page 300, Your Honor, paragraph.
Let me say something. I'm not happy with the order you trying to pursue in here, Mr. Hussain. You could have gone like in a different sequence and take me through your legal submission first,
Your Honor,
and then you take me to the evidence. And I know you go back to your submission now, and you will touch upon this again. But go on, I would follow.
Your Honor, I apologize. Your Honor, normally I would have taken you first to my schedule and said these are the grounds on the basis of which I am filing my immediate judgment application.
No, do you consider this this is part of the background, or this is part of your submission?
This is part of the background. My submission will be very brief. Once I give this background, my submission will be very brief.
I hope, Mr. Hussain.
Your Honor, I will.
I'll remind you to be brief then.
Your Honor, I assure this Honorable Court that, I thought the evidence was, Your Honor, when I was myself trying to look into the submissions, I thought the court will benefit more if these points are brought to the attention of the court first. Your Honor.
Yeah, it might work, might not. Well, let's see.
Yes, Your Honor. Your Honor, with regard to this submission, their reply to our statement of defense, which is very critical.
Right.
At paragraph 2.2, they have stated, I will just read the relevant part, which is starting from second line. In addition to that, the claimant as well pleads ignorance for such a mistake of law. Now they are referring to the mistake that they have made. However, pleading that although such a mistake of law, in law, cannot be condoned or excused, such a mistake has been as a reason of an unforeseen error in categorizing the provisions of the amended law under law number 3 of 2012 instead of law number 6 of 2018. However, with the leave of the court, at the presumption of such leave being granted, the claimant hereby amends all references to provisions of law number 3, under which the claimant has advanced his particulars of claim. Articles 18, 19, and 62 of DIC law number 4 of 2005, amended as law number 3. It shall be noted that the employment law which the defendant states is existing as the draft and hence does not have the force of law. Now, Your Honor, these were the points that I wanted this honorable court to take note of, that they themselves admit and agree that they have filed the case on the basis of the wrong law. But what they say, where my objection arises, is they say that this was merely a typographical error, merely a grammatical error, and we intended to file it under the right law. Now this has consequences for us. Because it is a submission before the court, we have to be very clear. Even if you file it under the wrong law, it's fine. You can make an application to the court may allow it. Subject to costs, of course, to the other side. Now, Your Honor, I want also to bring to your attention the draft order, which is volume 1, tab 5, page 93. This is our draft order, the immediate judgment application.
What is that again? Give me the reference.
Your Honor, I just want to bring to the attention of this court the release that what we are claiming.
No, where the draft? Where can I find the draft?
Draft order is at volume 1,
Yes.
tab 5, page 93.
Yes.
Your Honor, this order is, because this is very important, what relief we are asking in this immediate judgment application. So we are asking for following reliefs. That, number 1, that the claimant has pleaded the case under the wrong law. That is, this is at page 93.
Yeah.
That is the draft employment law, now enacted as law number 2 of 2019. That is yet to come into force, and therefore has no prospect of succeeding in its claim made under this law. Number 2, the claimant is not an employee within the meaning of Article 4 of the DIC employment law number 4 of 2005, and therefore the claimant's claims, even if they are considered under the DIC employment law, will not have any prospect of succeeding. And third, the claims filed by the claimant under first and second agreements are barred by limitation and therefore cannot be entertained by the court. And then the reliefs that we have asked for this court are, we must to dismiss all the reliefs claimed by the claimant in its claim form and particulars of claim as they were filed under the wrong law. Dismiss the claim in its entirety as the claimant could not have invoked employment law. Dismiss the claim in its entirety as the claimant cannot succeed in defending this claim even if it had filed a claim under the current employment law. Further, in the alternative, if this court is not satisfied with any of the following submissions, strike out the particulars of claim filed by the claimant, to which they have not, to which they themselves agree, and the claimant be directed to pay costs of the claim to be assessed by detailed assessment as on this date. So I just wanted to bring the relief, because now I will be going to some very critical points in my submissions. So I just thought to bring these things relocation of the court. Now, Your Honor, after this, there is a rejoinder which the claimants have filed to the immediate judgment application, which is volume 1, tab 6. Now, this is very, very important document for me. I think this is where I want to bring certain critical facts to the attention of the Honorable Court.
Yes.
This is their rejoinder to the immediate judgment application. Now, this is if you go to page 98, Your Honor, I just want to read paragraph 2.4, fourth line, or third line, second line, the reliefs sought by the claimant with reference to the claims submitted on the particulars of claim and the subsequent reply to defense have real prospect of success on the ground that the defendant is in grave breach of the provisions of the DRC laws and the employment agreements. In response to the allegation that the claimant has filed the entire claim on the basis of a law that has not yet been enforced, the claimant has already clarified the situation of this unforeseen error in its reply to defense and has further applied to Honorable Court for leave to amend the references as to law. Now, Your Honor, if you look into the date on which this application is filed, it is 29th of July 2019, and they have said that they have already applied for the court to amend the particulars of claim. As a matter of fact and as a matter of record, it is only on 7th August 2019 that an application for amending the particulars of claim was actually filed in this Honorable Court. So the statement here doesn't seem to be completely accurate. And if you move to the next page, page 99, it says, further it is well clarified with reference to the claimant's reply to the defense that the claimant is an employee within the meaning of the current employment law. So they're arguing that the claimant is an employee within the meaning of current employment law. But what they have not explained in their submissions anywhere is how does the claimant satisfy the requirements of Article 4 of the employment law in order to come within the purview of the employment law. And Your Honor, if you go into the next paragraph, which is 3.1, which is a summary of their reply, it is very important to read this. It says, in response to allegations raised by the defendant as to non-applicability of DRC Law Number 4 of 2005, amended as Law Number 6 of 2018, the claimant, without prejudice to the rights of the claimant, to further its claims against the defendant's breach of the provisions of DRC laws and employment agreements, admits that the claimant unfortunately stated the wrong nomenclature of the DRC Law Number 4 of 2005, but the claimant has applied to the court for leave to amend such unforeseen error of words. The claimant has not applied to the court at any stage at this time. Merely referring in their submission that this should be amended to read as follows is not an application for amendment, cannot be treated as an application for amendment by the court, because the set procedure is prescribed in the RDC for bringing an amendment application. It is further added that an entire claim cannot fall, and they are saying the reason which they are giving this. Now, this is the reason for the immediate judgment application. They are saying it cannot fall on the ground that the name of the law has been erroneously stated, as the same is claimed in the context of the FC Employment Law Number 4 of 2005. In addition to that, the claimant as well pleads ignorance for such a mistake. However, mistake has a reason of unforeseen error in categorizing the provisions. Then, Your Honor, if you turn to the next page, page 100. But before you turn to page 100, the last line of page 99 says the claimant reinstates that. Now, Your Honor, this is what I find objectionable. The claimant reinstates that the claimant has already filed an application under RDC 18.14 to this Honorable Court, seeking an amendment to certain provisions of the particulars of the claim by virtue of the documents. Your Honor, my question is, amendment application came forth before this court only on 7th August 2019.
1 week later,
Your Honor?
1 week later, after the submission.
It was 29th July 2019 is when they say that we have already filed. But it was actually filed on the 7th of August 2019. Anyway,
Maither, do we have explanation for this? Because if Eid holiday was then or what? Can you check? I think they were Eid holiday or something, Mr. Hussein.
Your Honor,
Let me double check.
Your Honor,
I think we would receive both this document along with the application just after holiday. There was
possibly, Your Honor.
we can do that.
Possibly, Your Honor. I just thought, Your Honor, because as a counsel, my job is to...
Well, and I fully understand. I just need to know I would ask, Mr. Shaib, do you have an explanation? Very fast explanation for this?
May I ask my colleague please to explain that one?
Why do we receive the application by 8th of August?
Yeah, actually we filed it on 24th of July even, online, 29.
29?
Yeah, we had a hearing on that date even, CMC hearing. So
I see.
after we finished even the hearing, we applied for this application.
But
And
out of
was
working
a
hours.
holiday.
Out of working hours.
Yes, it was holiday for 3
After 4 o'clock.
Yes.
Okay, I see. And that was Thursday or something?
Yeah, it was Friday, Saturday, I believe. After that, we paid even for the fees. Then normally the application date it comes on when I pay just the court fees.
Correctly?
Okay. So after they pay, it can be in the system. If they file
But I applied.
I know. Yes. It won't be effective unless they pay for it, Mr. Hussein. So, okay.
Your Honor, I'm sorry, I just wanted to...
No. I just need to know because you try to draw me to a certain picture which I really wanted to understand. Thank you very much.
Thank you.
Your Honor, now they're explaining at page 101, now they're explaining their interpretation of an employee within the IFC law, which is Article 4. Now, what they are saying, if you look at page 101 and if you look at point A, they say that the DFC employment law applies to employees who are based within or ordinarily work within or from the DFC. So they agree. The law does not differentiate between categories of workers. So they say that it applies to all, irrespective of whether you're an employee working within or working, even if you're not an employee. It applies to all categories of workers. Then, Your Honor, down below, paragraph B, the terminology...
Sorry, what is your argument regarding the first statement? There is anything wrong in this? In general.
Exactly what is wrong is what they stated term point B. This is exactly what I...
Oh, B, okay, not A. Because I couldn't see anything wrong with A.
Your Honor, A has to be read with point B.
It's a bit general one, yes.
Yes, Your Honor.
I see.
So point B they say, because this is where they explain what they meant by what they have written above at point A. The terminology includes from the DFC in where the employee is based within or ordinarily works within or from the DFC. The from meaning, so they are saying from meaning to state that the employee may ordinarily work for the DFC establishment from the DFC if not physically within. What I understood based on what has been written here is that what matters according to them as per Article 4 is that as long as they are working for a DFC establishment, no matter where they are working from. Therefore, the claimant working in the defendant office in JLP most of the time and for a short period in the territories of Sudan, so the first time they are admitting that they are working for us in Sudan, for an associate company of the defendant, so they are working for an associate company of the defendant. As instructed and sent thereby, the defendant makes the claimant an employee under the meaning and interpretation of the law. Now, Your Honor, if you read the next paragraph, further to the allegation that the claimant has failed to notify the court that it was gainfully employed in another company in Sudan for the time period, that is denied on the ground that the claimant was not working in Sudan during the time period of its claim against the defendant, as his employment with Sudatel started in September 2014, subsequent to the termination of his employment with the defendant in July 2014. This submission has been made before a court of law. Here they are saying that we were never employed by Sudatel. That's why I took, Your Honor, through that evidence in the beginning. to show to the Honorable Court that they were employed in 2009. Here they are saying that we were never gainfully employed in another company. The word they are using is, we were not gainfully employed in another company in Sudan for the same time period that is denied, on the ground that the claimant was not working in Sudan during the time period of its claim against the defendant. Now, Your Honor, I feel this is not correct. And at paragraph 3.5, they reiterate the same.
What do you mean you didn't feel it's correct? It's not about your feeling. What is your legal argument?
My legal argument is the evidence that I showed you in mixtures 5, 6, 7, 8 of our statement of defense, wherein we showed to this Honorable Court that he was drawing salaries during that period.
And he was present in Sudan.
I was present in Sudan, Your Honor. So, Your Honor, how can an employee file a claim? Now, first question is, my first submission is, should this, in fact, be brought to the notice of this, should have been brought to the notice of the court, that there have, after all, the killings have to be very fair and very specific, and all disclosures have to be made to the Honorable Court. Should this Honorable Court not have been informed, Your Honor, that yes, this is the true nature of our relationship. We were working in Sudan, and at the same time we were working in Dubai for this period. I have filed a claim, but this claim does not apply to the present claim because of these reasons. So we would have an opportunity to address those questions. Instead, we had to go and find the evidence and find out that where was the claimant working during that time period that forms the subject matter of employment in the present case. So, Your Honor, if for me this submission, I understand that the submission I made earlier of 7th and 8th is a very small argument. It's not, it may have been sometimes in the language writing in a particular matter. It's not so material. But in the instant case, Your Honor, to say that I was not gainfully employed, to say that I was employed after the relationship ended in 2014, is a submission which this court must rule on. It is for the claimant to explain to the court with cogent evidence why did they make such a submission. Those documents which I submitted in my statement of defense, and I read out our reply to the statement of defense, they did not say that the document which I have annexed or I have attached is not the order of the court. They did not say that this submission before the Honorable Court in Sudan they did not dispute that submission. They did not say that these salaries which they have withdrawn are not the salaries which they have taken. Your Honor, again, the point to be brought to the attention of this Honorable Court is that the case has not been filed on the basis that we have not paid them what is due to the claimant. The case has been filed on the basis of claiming certain additional rights that may be only available to an employee. So why we are bringing in this immediate judgment application, Your Honor, is first on the very obvious fact, which I don't need to argue, is that if it has been filed on the basis of a wrong law, there is no cause of action. If there is no violation of a legal right, and if the contract stems from a provision of a law which they have not relied upon, clearly there is no cause of action, and on that ground alone the case can be dismissed. However, if this court were to consider and give them an opportunity, give them the benefit of doubt, subject of course to the costs to the other side, that they can amend their particulars of claim, then the court can only do so if the court forms a conclusion on Article 4 and court were to hold this person as an employee. But to hold this person as an employee, this court has to be mindful of the most critical submission, which is the evidence that we have produced before this Honorable Court, along with our statement of defense, which was not refuted to by the claimant, which should be considered as an admission of that evidence. And if that admission were to be true, this reply that they have filed to the immediate judgment application, Your Honor, clearly states that they worked from September 2014 onwards in categorical terms, in clear, unequivocal terms, not without any iota of doubt and submission. They are saying that we were not an employee. This is an honorable court of law. Any submission that any counsel makes, any counsel admitted to practice by this court, must be careful before any evidence is submitted to this court, that it should not be misleading in even the smallest of small terms.
I agree with you.
Your Honor, at page 102, second paragraph. Further, to the allegation that the claimant has failed to notify the court that it was gainfully employed in another company in Sudan for the same period, that is denied. Your Honor, this is another point that bothers me.
Were you reading again?
Page 102.
Yeah, the fifth line.
Line third, sir. Your Honor, from the top, if you see.
Third of the second paragraph.
Yes, sorry, second paragraph.
Yeah. Yeah, he said he was not working in Sudan during the time he was employed in the DFC. Yes, what's next, Mr. Hassan?
Your Honor, I don't want to put anything else onto in with regard to this. And my last document that I want to show you is our reply to the claimant's rejoinder, because we also replied to this to the rejoinder, which is volume 1, tab 7, which is the very next document. Your Honor, if you look into my form itself, which I have submitted before this honorable court, at page 106, and if you look at the bottom of 106 and you count 8 lines up, and you go 8 lines up, it starts at point A, mere mistake. So I am pointing out that mere mistake in nomenclature of the employment law on this submission, the claimant has failed to acknowledge that it filed its case on the basis of a draft law. And it was not a mere error of law, as wrongly stated by the claimant. The claimant has wrongly stated that the mistake is measured on the nomenclature of the law, thereby effectively arguing that the substance of law remains the same. Whether the claim is filing under the DFC employment law number, so and so 2012, current law, or the DFC employment law number, new law, the claimant is knowingly making a misleading statement before this court. The defendant shall demonstrate below that the claimant made submissions on merits on the basis of the wrong law, which confirms the defendant's submission that the claimant is trying to mislead the court. Point number 2, that the amendment application has already been filed. The claimant has wrongly submitted that it has filed an application to amend the particulars of the claim. No such application has been submitted as on date. Now, the date is, I think it was submitted on 7th of August. The defendant shall set out below the procedural requirements that the claimant is required to follow. And point number C, the new employment law is prospective in nature and the principle of financial justice should not be affected. Your Honor, further, if you see, with regard to the periods of limitation that are there, there is no application on record where they have moved an application seeking leave of the court to that why they could not file their claim within that period of time. And then, Your Honor, if I may take you to page 108, towards the end, line number 4, further, line number 5, further, the claimant wrongly submits that the time period between 2014 and 2018 shall not be counted towards the 6th limitation period. The defendant has consistently argued that it is the claims under the first, second employment contracts that are time barred. As such, the defendant refutes the claim's submission that the time period for determining limitation did not commence in 2014. The claimant's submission that the time period commenced in 2018 has no legal basis. Then, Your Honor, I want to bring your attention after these 2 pages to page number, only 2 pages I want to bring attention to. Yes. Is page 113.
Yes, Mr. Zain.
Now, Your Honor, the important point for this court to take note of is they filed this amendment application was filed only after the CMC conference was held, and the honorable CMC judge told the other party that the only way I can take on record anything that you want to submit in relation to the amendment is through an application. Now, until that moment, they have stated earlier that we have moved an application and that we have written back. So they have not moved an application at all in this particular case. And this application has been made after the immediate, so the point to be noted by the court is, after we filed the immediate judgment application. This immediate judgment application was filed before the CMC hearing. And in the CMC hearing, They were told to file that this is the only way it can come up before the court. So my immediate application precedes in time the amendment to particulars of claim. Your Honor,
But that doesn't mean we should disregard looking to their applications.
not at all. Your Honor, I would never, not in the least, even remotely suggest to this honorable court that their application should not be looked into. But what I want to summarize for this honorable court right now, after going through the evidence on record, is my skeleton to the immediate judgment application. Skeleton for the immediate judgment. Sorry, it's Your Honor, I want to just now summarize my.
I'm on page 113. Do you want to say anything about it?
Your Honor, in this particular 113, I only wanted to point out the point that when they are saying that they have moved the immediate, they have moved the particulars of.
Oh, the time reference.
That point I wanted to, for the purposes of reference, that I wanted to take. The respondent's immediate judgment application, Your Honor, I have seen to have. It's here. Your Honor, I now want to finish my submission in 15 minutes, and I would request the Honorable Court to grant me these 15 minutes to sum up the submissions. And Your Honor, I shall do so relying on this with the help of the skeleton.
Nathan, how many? Do we have a full day or half day here? Full day here.
Your Honor, our skeleton is very critical in this regard. If you have a copy of the skeleton of the respondent that we have filed.
Yes, I do have. Yes, Mr. Singh.
Your Honor, with your permission, I want to draw the attention of the court. I want to now highlight the main arguments, which is page 3, alleged employment agreements. So there are 3 employment agreements that I pointed out earlier.
Yes.
The first agreement commenced on 1st November, ended on 31st of August 2010. Second commenced on 1st August 2010, expired on 31st July 2012. Third commenced on 1st August 2012 and expired on 31st July 2014. Your Honor, next page, 4, paragraph B9. The point is that the period of appointment under each of the alleged employment agreements commenced on the date of execution of the contract and expired on the date of expiry as mentioned in such agreements. None of these agreements were extended by the defendant in writing. Instead, the defendant executed new contracts with the claimant each time. No new contracts were signed after the third agreement expired on 31st July 2014. The claimant has alleged that the defendant has breached its contractual obligations under the employment agreements and is therefore liable to compensate. Paragraph B11. It is in this context of the alleged breach that the claimant has filed its claim under the draft employment law and not under the employment law number 2012 for a total claim of 1.3 million along with interest. The defendant denies this claim in its totality. B12. In order to succeed in its claim for the DFC courts, the claimant must demonstrate first that he is an employee within the meaning of the employment law. The defendant submits that the claimant has not pleaded the correct law. The claimant cannot merely rely on the employment agreements referred to above unless he is able to demonstrate that the 3 agreements are employment agreements and he is an employee within the meaning of Article 4. We have already shown to the Honorable Court how they have interpreted Article 4, and their interpretation of Article 4 is quite contrary to our interpretation and the way this has been interpreted. Now, Your Honor, paragraph page 5, we have mentioned RDC 24.1 and the requirements of RDC 121 are known before this court, so I will not read it again. I would draw this attention of this Honorable Court to page 7 of my, which is an important, there's an important para I want to refer to, page 7 of my skeleton, paragraph 5.
Yes.
Simply put, the claimant has filed its claim based on draft law, which does not have the force of law. Although the claimant has tried to dismiss this reference as a mere error in nomenclature, it is evident that the claimant was intentionally referring to articles of the draft employment law. For example, Articles 64 and 65 that were referred to by the claimant are not part of the employment law 2012. Similarly, there is no reference to Schedule 3 under the employment law 2012 that the claimant has relied upon. It is therefore clear that the claimant has wrongly submitted. Your Honor, once again, my objection comes from the fact that why are you saying that this is a simply error? This is not an error. Then why have you referred to 64 and 65 and Schedule 3, which is there in the draft law, but is not in the law number 2012? It would have been an error if they would not.
Mr. Hussain, even yourself describe it as wrongly submitted. I mean, wrongly by mistake. And what do you mean? Even in your submission, you didn't say it's intentionally they're relying on the wrong law. You just said they has wrongly submitted. What do you mean by wrongly submitted?
What intentionally was, I completely agree with all your report. I think this word intentionally should not have been there in our study. And it accordingly stands removed. What I meant was, by using the word intention, was not that they relied on it to remove the draft law, keeping draft law to be applicable. Let me put it in this way to give them the benefit of doubt. But then it has certain consequences for them. Your Honor, if you look into point J below, what is their claim? Their claims for gratuity, unpaid leave, airplane tickets, all stem from the draft employment law. Now, if I take you to the next page, which is page number 8.
Are you arguing, Mr. Hussain, that gratuity, unpaid leave, and airplane tickets won't be covered by law number 2012?
No, Your Honor, it is covered. It is 100% covered. But only it is covered in case of an employee. If he were to be an employee, then he could have claimed all the benefits under the employment law. Of course, gratuity is one of the most important things that an employee cannot be denied if he is an employee. But again, the word that I am referring to is an employee. Now, Your Honor, I don't want to take you through the few other pages where we are discussing who is an employee, what is the definition of an employee under common law.
Does the new draft law change? It's not a draft now, it came to application, I guess. Does it change the definition of employee, or is it still the same? I haven't.
It has slightly, as far as I can see, there is a slight change in the new draft law. I will. Should we go into that draft law, Your Honor?
Yeah, if you can, very fast.
The new law, which is in authorities bundle. Tab. Authorities bundle, tab 6, which is the third bundle.
Yes.
Employee definition of employee.
Where the old law can be found?
Employees defined in Article 114.
Page 1.
Page 114. Page 114. Sorry.
Page
Page 114
114.
of which is Schedule 1.
Article 4(1)(b)(c).
So they say that an employee is an individual referred to
Yes.
in Article 4(1), B or C. Now let's go to Article 4(1), B and C. With your permission, can I read Article 4 with this honorable court, Your Honor?
Go on.
Application of the law. Subject to Article 4(3). I apologize that there is a slight, this is not very clear text. Subject to Article 4(3). This law applies to any person having a place of business in the DIFC, including a body, authority, registry, or entity established by or pursuant to DIFC founding law, who employs one or more individuals. So that's not the case here. Subclause B, any individual employed by way of an employment contract by a person referred to in 4.1a who either is based within or ordinarily works in or from the DIFC. So to this extent it has not changed.
I see.
Or agree in an employment contract to be subject to this law, or any individual working or employed in DIFC pursuant to Article 4.2. So let's look at Article 4.2. 4.2 says, subject to Article 4.3, an employee may be employed in the DIFC pursuant to an employment contract subject to an applicable law other than this law. So that is not the case here. So no need to read 4.2. 4.3 says, nothing stated, notwithstanding the provisions of Article 4.2, the following provisions of this law shall remain to be applicable to an employer or an employee during the secondment. So that talks about secondment. So Your Honor, if we look into the key difference, if the question is whether the new law has introduced a new category, which means you can work from being outside of the DIFC, that has not happened. And I cannot read it, that particular point into the case. So to this extent, Your Honor, although I have not sufficiently researched on this particular point in great detail because no material is available, no conventions are available as of this moment, Your Honor. But it appears to be almost identical to the earlier provisions of the earlier law. Now, Your Honor, since you had asked me to come quickly to finish this quickly, there is a very important point. If we look into their first claim, they are asking for a relocation allowance. So if a relocation allowance Your Honor, page 14 of my submission, at point D, the paragraph D. Another important fact to bear in mind is that the claimant joined Sudatel under another employment contract and was relocated to Sudatel in Khartoum in September 2009. Furthermore, the claimant had also claimed a relocation allowance from the defendant. So clearly, it is, why am I referring to the word relocation allowance? At least one thing is established from relocation, that he moved away from Dubai. At least he was not permanently, at least relocation would confirm one point, that he was not permanently residing in Dubai. That is the only point that I want to bring to the attention of this honorable court by referring to the word relocation. Then on page 15, which is the next page, if you see, there is point JJ. This is also a very important point.
Yes.
In this point, I want to tell this, I want to inform this honorable court that the defendant or the respondent had never compelled the claimant to report to the workplace at any given point in time for a set number of hours. The sheer number of absentee days of the claimant, which this honorable court has seen, would technically entitle the defendant, assuming he were to be an employee, to terminate the services of the claimant for the breach of the employment agreements. However, the defendant never exercised any control over the claimants, coming and going, as the claimant was not an employee. In addition, the claimant also would never apply for leaves as per the terms of the employment agreements, and neither was he compelled to do so. Furthermore, the claimant was not prevented from being employed in another company, which typically is the case with conventional employments, where the employer can prevent the employee from working with another company. Next point, KK. Therefore, the manner in which the claimant conducted himself, it seems as though the claimant was more of a consultant rather than an employee. The test of sufficient control by the employer falls flat in the case of the claimant, who was never within the control of the defendant. In the next point, it is stated, with regard to the claimant being a consultant, the defendant in fact had required the claimant to sign the consultancy agreement after the claimant was relocated to Khartoum in September 2009. This is, Your Honor, this time period is very critical. And although that consultancy agreement was not signed, but why did we give this consultancy agreement to him? Because he moved to Khartoum. We still wanted his services. He was terminated, he was not working with us as an employee. So we requested him that please sign this consultancy agreement for the purpose of record. He did not sign that particular consultancy agreement. But we had no choice in order to utilize his services, but to continue with him on the same basis, on the same terms and conditions as existed in the earlier agreements. The nomenclature said it's an employment contract, but in effect the relationship was not that of an employee. Next page, page 16. At page MM, please note that we refuse to sign the consultancy agreement. Then let's come down to the last paragraph, QQ, of this page 16, which says, in conclusion, it is submitted that the Employment Law 2012 applies only to those employees that satisfy the conditions provided under Article 4 and the definition of an employee. Considering that the claimant is not an employee within the meaning of Article 4 of the Employment Law 2012, nor can he be considered an employee under one of the principles of common law, the Employment Law 2012 will not be applicable to him. If Employment Law number 2012 is not applicable to him, the case falls in its entirety. These three contracts, which he is referring to, are not one continuous contracts. There are three different contracts. The time for commencement and time for termination is mentioned there. Now, Your Honor, my last ground, which is assuming that everything goes is everything that I argued before this honorable court. If I have failed in my duty to convince the court on the first two issues, the third issue that comes to my rescue, Your Honor, is the issue of limitation. I have made a chart which I request this honorable court to look into at its convenience. In this chart, dates are mentioned: date of commencement, date of conclusion of the contract. Then all I did was, I did a simple calculation of 6 years. I looked at claim number 1, I looked at claim number 2. I saw by how many years claim number 1 and 2 were barred by limitation. Then I thought, is there any application on record which where a leave has been sought from the court that why they could not bring the claim within the stipulated time period? That is an important consideration for this court in order to allow any claim. And I could not find any such application. As such, I was not in a position to make my submission in that regard.
So you made this limitation argument based on the other argument that these are 3 different contracts, and which each of them starts and ends in certain days, and the contract after is a completely separate document. It's not renewed, it's not continued. Is that right?
Your Honor, you see that terms, even under the 3 employment contracts, if you see, sometimes the salaries have been changed. There are variations. It is not one continuous whole. It could have been treated as one continuous whole if it was an indefinite contract. It uses the words used are it's a fixed term contract. A fixed term contract is for a certain period of time. Even, Your Honor, under UAE law, when an employee is engaged by a firm and the visa is issued for, let's say, for a period of 2 years in a fixed contract, in a definite contract, it is understood that he has to apply or she has to apply for a new visa after the expiry of the term. So the point here is that, which I'm trying to argue is that no matter how this honorable court treats this contract, after all, the Article 38 of the Law of Limitation of the U.S. Code law, which talks about the limitation, it has prescribed a certain period. There's a prescriptive period of 6 years. Within this prescriptive period of 6 years, they must file a claim. And if they have not filed a claim within this period of 6 years, they must give reasons to the court and ask the court to conduct such claim. No such application was filed in this regard. And you know one very interesting thing. Claim 1 and 2, if you look into the record, is barred by limitation. Now, one fascinating thing that I came across in this case is that even if you say that claim number 3 survives, claim number 1 and 2 is barred by limitation, claim number 3 survives. Assuming if claim number 3 survives, for the sake of an argument, if we look into the draft law that we just looked into, law number 2 of 2012 that we just looked into. What is interesting is, the first part of law number 2 says, the employment law 2019 repeats and replaces. So it uses the word repeat and replace the old existing law. Then it says in number 2, except as otherwise provided in this law, anything done or omitted to be done pursuant to or for the purpose of previous law, means 2002, is deemed to be done or omitted to be done pursuant to or for the purposes of this law. So it says, whatever we have done or whatever has happened, should we go together, Your Honor, on this point? Because this is a very interesting point of law, which is not, there's no judgment I have seen so far from this honorable court on this issue. And the reason why, Your Honor, I am citing this is because if Your Honor were to agree with me on the interpretation of this law, then the relocation period under Article 10 is only 6 months.
What are you reading? Number part 1?
Your Honor, it's page 84.
Yes.
You have Your Honor as the...
Yeah.
Yes. And with your permission, Your Honor, let me read part 1, because that's only what we have to read. This employment law 2019 repeals and replaces the employment law 2005, which is DFC law number 4 of 2005, as it was enforced immediately prior to the commencement of this law, the previous law, and may be cited as employment law 2019 or this law. Point number 2, except where otherwise provided in this law, anything done or omitted to be done pursuant to or for the purposes of the previous law is deemed to be done or omitted pursuant to for the purposes of this law. Now, Your Honor, this is a very important point and a very important legislation where they are saying anything that happened previously should be judged by the provisions of this law. And then clause 3 says, this is the most difficult clause to read and the most amazing clause to understand.
It is.
Without limiting the generality of 1-2. So 1-2 is whatever happened earlier will be treated as reference to the new law. Without limiting the generality 1-2. And subject only, now this is very important, to articles 14, 15, 10 and 61-2. Now, Your Honor, the word is subject and subject only to. Your Honor, the word is not subject to. The word only has been used by the legislators to convey a very important point, which means it is not subject to any other provision. So, and subject only to Articles 1.4, we will read it below. Articles 1.5, we will read it below. Articles 10 and 61, the repeal and replacement under Article 4.1 shall not effect. But subject to 10, subject to 61.2, anything else, it shall not effect any right, remedy, debt or obligation accrued or to be accrued by any person or any legal proceeding commenced or to be commenced in respect of any such right, remedy, debt or obligation under the previous law, and any such legal proceeding must be instituted, continued, here in our case continued, or enforced, including any penalty, fine or forfeiture, under this law, without prejudice to any right, remedy, debt or obligation which has accrued or incurred prior to the commission of this law. So what does it mean? It means that everything has to be brought in within the purview of the applicable law, and if there are any continuing proceedings, even they have to be continued in accordance with the purview of this law. However, in order for a case to fall within the purview of this law, we should be mindful of Articles 1.4, 1.5, 10 and 61. Now, Your Honor, why they introduced the article limitation in Article 10, I would like to read first 1.4 and 1.5 and then go to 10. 1.4 says, where there is no equivalent provision in this law to a provision in the previous law, the relevant provision in the previous law is deemed to survive the repeal and replacement under Article 1.4 until such time as necessary for the purposes of any legal proceeding specified in Article 4.3b the fact that a provision in this law reduces or extinguishes rights in the previous law does not prevent it from being an equivalent provision for the purpose of Article 4.3. 1.3. A claim in respect of any part of penalty due pursuant to Article 19.2, which would otherwise be excluded by 19.1, may be brought prior to the commencement of this law. Now, 1.4 to 1.5 have to be read in context with 1.3. 1.3 says, without limiting the generality of 1.2, and then it says, subject only to Articles 1.4, 1.5, Article 10. Your Honor, Article 10 is now important. Article 10 is on page 86, Your Honor. Article 10 says, subject to Article 61.2, a court shall not consider a claim under this law unless it has been brought to the court within 6 months of the relevant employee's termination date. Now, Your Honor, when I looked into the convention on why they introduced this period of 6 months, as proposed to be earlier, there was no time period prescribed in the law. This was because in the penalties were to begin from the last date of employment and were to be calculated on the last drawn salary per day, which means an employee could as well not institute a claim until 5 or 11 months, and the claim could have been instituted after 5 to 11 months. The employee would still have been within limitation, and the employee would be able to claim all that money. Clearly, Your Honor, this was something which the legislature wanted to avoid and prevent. So if I were to look at clause 61.2 also, which is at page
You saying this is like Article 10 for limitation applicable to the current proceeding
Your Honor,
by reference of Part 1 of this law?
Your Honor, it has to apply, as far as I could understand. Your Honor, I tried to read this in several ways to see whether my conclusion is correct or it is wrong. And then I looked at, it says the word subject only to. So why does it say subject to? It doesn't say subject to, it says subject only to. And then it uses the word Article 10. And then it uses the word 61 subclause 2. Now, Your Honor, can you just read 61 subclause 2?
This would be very harsh interpretation, but if it's right, it's right. Go on.
Your Honor, it is indeed, because it is like a law, Your Honor, which they brought in to cover something which a lot of people were protesting against, saying that this law should change, this law should change. So apparently there was a judgment of this honorable court, wherein they also said that even when we have to award the cost under the old law, we should be reasonable, we should be mindful of the circumstances. So the courts then exercise discretion. Now what they did here apparently seems to be a situation, Your Honor, wherein they clarified the law and left no scope for any interpretation. It could work in our favor, it could work against us. Your Honor, with your permission, at page 105, Article 61 says proceedings under Part 9. Now, I want to read 61 subclause 2 because there's a reference in Article 1 about it. Article 61 subclause 2 says, a court shall not consider a claim under this Part 9 unless it is brought to the court before the end of the period of 6 months, beginning with the later of the date on which this law comes into force and the date of the act or failure to do something to which the complaint relates, or where the complaint satisfies the court that there are circumstances which justify disapplying Article 61 to such other period as the court considers reasonable. This is the point, Your Honor, where the legislature, while being very strict on Article 10, created a sort of a ground for the complainant to come forward and explain the material circumstances. Because Your Honor pointed out also that it is very harsh. Because Your Honor, the reason, if because of some personal extraordinary circumstances I was not able to bring a claim, this prevents me for making an application before the Honorable Court and bringing those circumstances to the notice of the Honorable Court, which this Honorable Court may take note of. So, Your Honor, if we look into the scheme of this new law, which applies to the instant case, and that is precisely the reason why we included part of discussion at Schedule 3C of our skeleton, then none of these three claims survive. So, Your Honor, my simple submission before this Honorable Court is whether this Honorable Court applies the new law, whether this Honorable Court relies on the old law, or whether this Honorable Court, the first thing for this Honorable Court is to see whether this Honorable Court would permit the other party to make an amendment to the particulars of its claim, considering that this amendment application was filed on 7th August after the immediate judgment application. So clearly it has to be brought within time and it should not be too late. That is what RDC very clearly stipulates. But assuming that this Honorable Court where to exercise its discretion and this Honorable Court where to allow the other parties to make its amend its particular claim, my submission then would be that, Your Honor, I have myself before this Honorable Court argued a matter where I had made a mistake of law. So I do understand the position of the other side as well. But in such a way, this Honorable Court had asked that before I can submit my particulars of claim, I must pay all the costs to the opposite party. In this particular case as well, I am requesting this Honorable Court, assuming that it is allowed them to amend their particulars of claim. In such a case, all the costs accrued until date should be paid by them to us. And second, if there is no cause of action in the instant case as the record exists, so clearly the case could be dismissed on this ground. If the case is not dismissed, then before they are given a permission, the court must look into the issue whether this employment law applies to them or the new employment law applies to them in the first place. We just saw that the new employment law did not amend or change Article 4 definition. So, who is an employee in the meaning of the FZE law still remains the same. Then, they should be an employee in the meaning of the FZE law. Now, even if this court were to treat them as an employee within the meaning of the FZE law, then my submission is that the period of limitation sets in and claims 1 and 2 are barred by limitation. What survives then is claim 3. In that case, my last submission is then the court must look into the effect of the new law. And if the court were to look into the effect of the new law, claim number 1, 2, and 3 are barred by limitation. Under such circumstances, there is no competitive reason why this case should be referred to trial. Even if this case were to be referred to trial, there is no way, there are no circumstances that exist on the basis of which they can argue that they have a case and there is a reasonable prospect of success. It is precisely for these reasons, irrespectively of these 4 or 5 points, that we move this immediate judgment application. I remain available to this Honorable Court.
Well, Mr. Hussain, are you seriously arguing that the limitation under the new law for a 6-month time period applicable to the old case which was filed, proceeded, and maybe by the CMC time, so that was in July, the new law has not come to application yet. I don't know, how can you imagine this? I mean, that the new law would be retrospectively applicable to a proceeding already initiated.
Your Honor, this is the difficulty I was also confronted.
Well, that means the new law says you go strike out every case filed before the court if it's not in compliance with the 6 months requirement. That would mean
Your Honor, it doesn't seem right.
all cases for the last 6 years will be striked out if it's to follow your argument, Mr. Singh.
Your Honor,
So really,
Your Honor, you are very correct. To be honest with you, because I'm before the court, not that it helps my case, but I must also tell you that I share the same sentiment. My question is it fair? My question is, if the case was filed prior, then the limitation that is granted earlier in the earlier law must apply. So the case should be judged by the period of limitation under the earlier law as opposed to the new law. This is what I would do, and that's precisely the reason why I included this as Schedule 3 to my skeleton as opposed to the main body of my skeleton. And that is why I'm arguing this as an alternative to this before this honorable court, and not as my main submission. But in any event, my clause, by virtue of my limitation argument, claims under Agreement 1 and Agreement to any fail. So I'm okay with that. So then the only thing that I have to deal with is the claim under Agreement 3. But Your Honor, I thought it because there is no guidance, there are no notes, and I think an important ruling from this honorable court on this point would help many litigants in this country whose cases are pending before the honorable court. But when I read Article 1 and when I read Article 1 to Article 1.5, and I compared it, Your Honor, with what it says subject only to, and then I looked into Article 10 and I looked into Article 61.2, I could not think of any conclusion other than its retrospective effect. And it says that this agreement, this law shall come into effect from August, I think, 28th of August 2019, which means whatever happened earlier, normally, Your Honor, it didn't seem right to me. But I am just bringing, as an officer of this court, I'm bringing this argument to the attention of the court for guidance.
Well, thank you for Mr. Hussain. I think I have heard enough from yourself. This is your submission in both applications. The first one, your immediate judgment application, and second, in their application to amend.
This is only in respect of my first application, my submission in respect of my first application. But I must confess that some of the points which I'm going to touch upon in that are already covered.
Yes.
By the submissions in this application, and that was the purpose, Your Honor, of taking you through the voluminous details in the beginning.
Well, no worry. I think I can give you another chance later on if there is any other points you need to cover after hearing from Mr. Shuaib. I'll turn now to Mr. Shuaib. Mr. Shuaib?
First of all, my name is Musaab, not Shuaib.
Oh, Musaab. I'm very sorry. Excuse me for that, please.
No, it's okay.
So, do you think you want to take a break? How long you would your submission would take? You think 1 hour or more?
I think around 1 hour at least for the response for the immediate judgment application.
Yes, and
then we need another round for the application for amendment. So we can take a break if you want, but there is no issue. Maybe 5 minutes or 10 minutes.
Yeah, because usually we take break at 1.
Okay, so
but we can take maybe a short break, then we can finish.
Okay.
Maybe we can finish before 2 or 3 or 2:30 for maximum. Is that right?
Yeah, that's right.
Sure.
Yeah. Okay.
Is it okay if we break for half an hour now? And we will be back at 12:30.
Okay. Thank you.
And we'll finish.
Thank you.
Thank you.
All rise.
Yes, ma'am. Mr. Musaab.
Yes.
Yes. First of all, please, excuse me for pronouncing your name in the wrong form.
It's fine.
You may start.
Thank you, Your Honor. Thank you for allowing me to represent myself in front of this honorable court.
Well, that's your minimum right, I guess. You didn't have to thank me about it.
Yeah, I think so. Okay, I will try to start by giving a little bit brief about myself and the relationship with the defendant. My name is Musaab Elsir Abdelsalam. I'm the claimant, then of course applicant on the amendment of the claim, and here I'm respondent to the immediate judgment application of the defendant. I work for the defendant from 1st November 2008 until 31st of July 2014 continuously through 3 consecutive employment agreements. You can look at the reference if you want, then you have it there as well. The defendant has breached the obligations related to my labor rights and end of service benefits and gratuity. And after several attempts of chasing the defendant to pay my entitlements, I had no option rather than going legal. And then in 2018, I appointed a firm, which is the Dhahi office, and we sent the legal notice in March 2018 to the defendant, who responded and promised to get back with a resolution. And after that, I had several meetings and discussions with them, promising, okay, we'll look at how we fix it, etc. And we spent almost 1 year without real progress. So then I had to go to the court, and I filed the case in May 2019. I would like also to give a brief about the nature of the business of the defendant and myself as an employee of the defendant. Expresso Telecom Group is the international telecommunication group with operations in West Africa. Actually, it has no operation in UAE. So the Dubai office is like a holding company managing the overseas business and the operations outside. And this is why most of the roles and most of the tasks are related to the operations outside. So most of the senior staff, including myself as the head of the technology division, I was the chief technology officer for the group. And initially I was the network planning and operation director for the whole group as well. So I was responsible for 5 operations in West Africa. All the technology aspects related to those operations, in design, implementation, operation, relation with suppliers. Actually, we deal with international suppliers from different countries. Relation with regulators also regarding their permits and regulations, etc. And of course, the setup of and development of the technical team. So like training tools, etc. All those are part of my responsibilities. So by nature of the job, most of the work actually used to be outside the UAE. UAE was like a hub or the administration office. And myself and the head of like CIO, head of information technology, CMO, etc. Most of us used to travel at least more 40, 30%, sometimes even more than 50% of the time. It depends on the year. If you have like more projects, new rollouts, etc. So it's like by nature, it's a travel-based business. I would like to respond also to the 3 points which the defendant built the immediate judgment application.
So you're saying the DFC office is not operational office, but it's rather admin office, administration?
Actually, there is no operation here at all. It's completely administrative office. All the operations...
They administer the overseas companies?
Yes, exactly.
That belong to the Expresso telecom. They own them or subsidiaries, or they are members in them? Or?
No, they are subsidiaries. They own the majority or 100%.
Oh, I see.
So it varies. Some of them like 70+%, some of them like 95%, some of them 100%, etc.
Are you a technical person or administrative person?
No, I'm the head of technology.
Head of technology.
Yes, I'm responsible for all the mobile networks, fixed networks, all the platforms that we need to.
So you're an operational person.
I'm operational person. Yes.
So nothing to do with the admin.
Sorry?
There is no role for you in the DIFC?
Yeah, most of my work is related to operations in West Africa. Yeah. So I need to be there, like if you are building new networks, towers, etc. I need to travel to meet suppliers in Europe, in China, and so on. So most of my role is like moving around, but I was based in Dubai. My office was in Dubai. I have a workplace, an office in the defendant's workplace. And the point that raised by the defendant, that I was not working from the DIFC or within the DIFC, the defendant itself had no operational office ready for use in DIFC until 2012. Because the defendant bought the office in DIFC while it was a development plan. So it was not built yet. It is in the Ahmad Park Tower. And all the staff of the defendant until 2012 used to work only from the office in GLT. The defendant has 2 offices, one in GLT, Numeric Towers Dubai, and the other one in the DIFC. So for my first 4 years of employment, all the staff used to report to the office in GLT. No one was reporting to the Dhahi FZE office. The defendant has the office, owns the office, but it was not existing, was not ready for use, it was still under development, and it was just become ready for use and handed over to the defendant in 2012. So this is also a point that I would like to highlight. Then I will come to the 3 points that they highlighted. The first one is the mistaken law, and of course we admit to that, and that is the reason actually we apply for amendment to correct this mistake, and we believe to this honorable court to give us the leave to amend, or to grant us the leave to amend it. The other part related to the end
Is it mistake or the wrong law that you wanted to address? Do you know the difference between mistake and wrongful? Wrongful, like, it might look like, at the time you thought, you know this is draft law, you know this law coming to force 2019, but you thought this is the law would be applicable to your case. Or, mistakenly, you think this is the only existing law, and that's why you made a reference to it without bearing in mind this law is amended several times. There is a couple of versions available to this law. So which one was exactly in your mind?
Okay. To my understanding,
I'm trying not to make a mistake because you already have a bleeding, so
yes,
try to
yes,
make
yes.
answer. I mean,
I will
coherent with the bleeding given before.
Okay. To my understanding, we understood that was the law. However, for more clarity, I would like to get the seek support of clarity, more clarity from my colleague, because they are the law firm who advised me based on this input. But the understanding for me, we were applying using the applicable law.
But so once you file your claim, this is still remain a draft law. It was not even applicable. It was
That's a mistake. It was wrongly named, I guess. I can name it that way. It was wrongly stated.
But it's not wrongly stated. As Mr. Husseini said, he was referring to article that did not exist in the old law. It only exists in the draft law.
Yes.
So from where you got that draft, which you already based your substantial case on?
If you allow me,
it's really strange. I mean, how?
Yeah, if you allow me, I can get clarity, more details from.
Well, they have no right of audience in here, but if they can whisper to you and tell me what is the matter, then I can, yes.
As I mentioned, the understanding was that that was the applicable law, and later we understood that it's not yet applicable, and this is why we requested to amend it.
Oh, so you didn't know that was like, let's say, what's called a draft law?
Yeah, we thought it's like enacted or coming into force because I think it was drafted in 2018.
Yeah.
So by the time of 2019, we thought that it's going to be the applicable law. And then later on, we discovered that it's not correct, and immediately we admitted to that and we requested for the amendment.
But I even myself seen this draft November 2018, but I don't know what happened to it until I've recently seen it came into force. So you thought that draft in your hand was the law that you need to rely on?
Yeah, it's going to be the applicable law, or the applicable lawyers at that time.
Go on.
Okay.
Mr. Hussein doesn't like this, but you go on.
Yeah, I will just say the truth. I'm here to tell facts. Even if we do mistake, we have to admit the mistake.
Right.
However, I think, and I believe to the court, for the sake of justice, not to, of course, dismiss a case just for technical error like that, or a misunderstanding maybe. I think the main intention is to seek justice, find the rightful acts, and we act accordingly.
Well, understand, you're seeking justice, but before you're seeking justice, you need to be honest with yourself first.
Yes.
You need to be clear to yourself, to the court, to your opponent as well.
Yes.
And lay down all facts, all related facts, whether in your favor or even against you. And then list of issues and make a clear pleading. You should have, like, let's say, disclose all of related information, such as your proceeding in Sudan. You know what I mean?
Yeah, I will clarify that point later.
Yeah, I understand.
Actually,
that I said, before you seek justice, you need to be, just.
Okay, I think we have tried to do exactly what your honors have said. I have tried actually to disclose all the information which I assume relevant to the court without doing like duplication or providing irrelevant information. Whatever I thought it's not relevant, I just didn't disclose it. When they when they brought something to the court, I responded and clarified that why I didn't include it at the beginning. Okay. Okay, then the issue related to the time barring. My understanding, since the employment was continuous employment till 31st of July 2014, the main event of breach have occurred actually on this date, which is less than 5 years since the date we filed the claim, and it was less than 4 years from the date where we have sent the.
So when you say it's continuous,
yes,
employment relationship, how you refer to the documents you've been signing, like 3 different documents?
Those are completely employment agreements. All the employment relationship requirements have been fulfilled. I was reporting to the office. I was doing the assignments and work assigned to me by the defendant. The defendant was, on the other side, was paying salaries on monthly basis continuously for 6 years, except the periods which I have claimed, where like some salaries not paid or partial salaries not paid. The claimant, the defendant issued a visa for me in Dubai. So if I was not an employee in Dubai, I shouldn't get the visa for Dubai. If I was employed for Sudan, then I should get a visa in Sudan. The defendant issued continuously for 6 years my health and medical insurance cards for myself and for
And
my
is it
family.
standard in the company that they issue new contract instead of renewing the same contract? Or?
The most practice is like that. I have never seen any extension, frankly. All of the practice I saw for I have colleagues who have been working for like 10 years. Even the HR director who has a witness statement here has been working for 11 years now, and he's also working with these fixed term agreements. However, I have another justification for that. If you look at the 3 agreements, the role changed from one agreement to another. Remuneration also changed. Some rights and obligations changed. So instead of extending, which becomes not an option since we changed the terms and conditions of the agreements, the only option was, of course, to go for a new agreement. However, there was not a single day gap between those agreements. Moreover, the second agreement was signed before the expiry of the first agreement. The first agreement expired on the 31st of August 2010, and the second agreement was signed on 1st of August 2010. Actually, that was a promotion.
You're saying this what made you in a continuous employment relationship with them?
Absolutely.
No single cut-off.
Sorry? Yeah, there is no single cut-off. There is no any interruption regarding the rights or obligation from either side, like salaries being paid for all this period, work has been delivered from my side for all this period, other requirements for the employment has been fulfilled. Even the point related to the travel raised by the defendant, those travel or business trips were assigned by the defendant itself and for the benefit of the work of the defendant. And even all those travel costs was borne by the defendant. So I wasn't traveling all of that from my personal pleasure and paying for that from my personal pocket. All of this, also it's sometimes a headache to keep traveling, and as he mentioned, sometimes we arrive and on the same day we travel to another destination. It's not fun, it's really hard work. And actually, I have mentioned in my response, I didn't take any leave or vacation until I got married. I have been working continuously for 4 years, almost 4 years, and the only leave I got was in the third employment agreement, so I didn't get any leave in the first or second employment agreement, and that one was when I got married, and even I didn't get enough leave, so I didn't have honeymoon. So I just got like time to go to have like ceremony with my family and so on, and came back to work.
Do you have any document like let's say, quantify your accumulative leave days?
Yes,
Since then?
yes,
Do you have any
absolutely.
evidence
Yes.
showing,
Yes.
like let's say, your holidays entitlement is accumulative of 2 or 3 different contracts?
Yes, actually, if there is as I mentioned, I have been chasing the defendant since the expiry of the employment, which is it's expired of July 2014. I have email correspondences annually, every year, right from 2014. Actually, 7 days, on the 7th of August, immediately 7 days after the expiry of the employment, I have exchanged emails with them, and I have these emails going between the two parties annually, from 2014, 2015, 2016, 2017, all those have been provided as evidence as part of my particulars of claim. So in those, there is one file.
Can you take me through one?
Yes,
please?
yes, please. If you go to the defendant's bundle, by the way, if you allow
Number
me,
2, exhibit.
yeah, if you allow me, Your Honor, just to avoid the duplication and for the housekeeping of the court, we didn't duplicate because there was some sort of coordination. We didn't duplicate whatever document that they provided. So whatever they provided, we just rely on what they. So volume 1.
Volume 1.
Tab 9, Exhibit 2, page 168, all the way through page 177. And if you look at page 187,
This is exhibit 2, isn't it?
yes, Exhibit 2 is showing the email correspondences.
Yes.
Every year, I've got a sample of each year email correspondences.
Yes, go.
And if you look at Exhibit 4, page 185.
85.
Yes, 87. It shows, this is the document sent to me by the defendant. It shows, like gratuity, they put 84 days.
Yeah.
Because what they proposed, they said, we look at this as 2 separate employment agreements and employment periods. They look at 2008 to 2009, and then from 2010 to 2014. So if you look at the date of join, they put 1st of August 2010, and date of leaving, 31st of July 2014. 4 years, they considered together as continuous employment, and accordingly, they assumed gratuity of 84 days and paid leave encashment for this 4 years, 72 days, which exactly as I mentioned, 2 years I didn't take leave, and then the 3rd year I took the leave for my marriage.
Yep.
And then the other one, you see the first contract, what they call it first contract. You see the date of join is 1st of November 2008, and date of leaving 30th of September 2009. So they were denying the period from 1st of October 2009 until 31st of July 2009, where I used to have to be on assignment in Sudan, as instructed by the defendant, which in accordance and full accordance of the provisions of the employment agreement as signed with the defendant.
So you're saying at least they're treating the last 2 contracts as a one
Yes.
continuity?
Yes, exactly.
Even if they want to argue the first one is a bit different or
Exactly.
whatsoever, so the 2 remaining one
They
was
consider-
treated as a one employment relationship,
Absolutely.
according to that. And there is more than one document?
Yes, this
Next one is-
this
it's the
table
same.
has been moving in and out every year. If you see the dates,
Yeah.
2016, 2017. So, and
Can I see the email attaching this? Do you have it?
yeah,
This
the
was
emails,
sent
the emails
as
on
an
the other
attachment?
exhibit 2.
Okay. Page number?
Yeah, we'll give you the pages. For example, here, if you look at page 173, you'll find an email from Faisal Babu Morkat. This is from the finance and accounting department.
Yeah, Faisal Babu.
Yes, he said
This is in the March 7,
Yes.
2016.
2000, exactly February. This is 25th of February 2016. The second one in the middle, not the first one, where because I want to show you the details. He mentioned that, dear Musaab, assalamu alaikum, in connection with the audit of our financial statement, Please confirm your account balance with Expresso Telecom Group Limited as on the 31st of December 2015 as given below. Final settlement balance $108,519 US dollars. So if you look at the table, which we have just seen, it is the same amount in the table, equivalent to 398,811 dirhams, which shows the same two periods, the 4-year periods and the
I mean the table you've been seeing before.
yeah, this is page 187. Yeah, the table we saw before, yes. So all the way they were admitting the 4 years continuous employment plus the first year. The debate and the dispute was on the 10 months, actually, it's less than 1 year, 10 months assignment in Sudan. And that assignment was instructed by the defendant to do it. And as I mentioned, this is in full accordance to the, with the employment agreement. So I had no option but to accept. Because in the, if you look at the employment agreement, tab 2, tab 3, yeah, tab 9.
Yes, go on.
Okay. If we look at tab 9, page 155.
Yes. Is this your first contract?
Now I will show you the first contract, okay? First contract, page 143.
Yes. Yes, that the other one.
Yeah, if you look at point 1.2,
Yes.
the place of work shall be the company's Dubai office. However, the company serves the right to require the employee to work at or be relocated for business reasons to any such other company work locations where the company deems necessary. The company shall support the employee's displacement in a reasonable manner reflective of his status within the company. Another point I would like to draw the attention of the court to, if Your Honor allow me. If you look at the address in the same page, the address of the employer, it shows Expresso Telecom Group Limited and registered in the DIFC, whose registered office is at 3103 Sabah Tower 1 JLT Dubai. So that was the workplace I instructed to work at, according to the agreement. Although the company is registered as a DIFC, as I mentioned. Mm-hmm. The second agreement as well shows the same address of the employer. So how come they say that, okay, I'm not reporting in a place where they ask me to work on another place? So the fact they mentioned that it's a DIFC company, in the agreements, all the agreements, they refer to the DIFC employment law and other applicable laws of the DIFC, which means the relationship between the two parties are governed by the DIFC employment law, and this is why we filed the case. Another part, if you look at page 164, you will find the salary statement, or my bank account statement actually. It shows the salaries going continuously, and even named as salaries, not as consultancy fees.
Yep.
If it was consultancy, it should be like consultancy fees. And I never heard of chief technology or chief executive officer as a consultant, usually. And I have, like, if you look at I have also attached some of the business cards which were issued by the defendant to me, showing that this is my title, not a consultant. So a consultant cannot go to anywhere representing himself as the head of technology or chief technology officer of a company. Because chief technology officers or chief executive officers in general,
So where is the business card? I haven't seen it.
It's here.
Yes, sir. Right.
Yes. Check it. Yes, here. It's page 386, tab 11, on the same volume. Volume 2, sorry.
Volume 2?
Yes, volume 2, sir. Tab 11.
386?
386, yes. So this is like the business card for my role as Chief Technology Officer. Another one is my business card for Network Planning and Operations Director. So, and the defendant never claimed that those were fake or something that I made up myself.
Yes.
Another point is I attached also a copy of the employment visa issued by the defendant, me, and it says also the IFC as mentioned in the visa. And actually it was issued from here, from the IFC. And all certificates were issued from here. If you look at document 3, on same tab 11.
What page?
Page number. It's page 361. It says the sponsor is Expresso Telecom Group, the IFC, and it says my name and it says Communications Director. This as my role or profession. So if I was working for another company in Sudan, why do I need to have a visa? And why need the visa in UAE? And why should the defendant issue this such a visa for me? Another point regarding the consultancy agreement. The proposed consultancy agreement was proposed in 2009 and has not been agreed by the parties, and therefore the employment agreement continued, and the defendant did not terminate that agreement until 1st of August 2010, when I got promoted actually. If I was a consultant, they should stop that and should not get engaged in another role. I got promoted from the director level to the chief executive officer level, and I become the group chief technology officer with the increase of my remuneration and salary, etc. So the assignment in Sudan was only for 10 months, and even the bank statement they provided, it shows that the payments were only from 2009 to 2010. Then, what about the remaining period? Assume that that was a consultancy or other employment, whatever, which is not true, of course. Then, what about the period from 2008 to 2009 and from 2010 to 2014? Those were employment, full employment, with employment agreements in place, all employer-employee relationship fulfilled, and so on. So I don't see any logic for that. I would like to highlight why I didn't add this at the beginning as part of my particulars of claim. First, I never thought this was going to be like a dispute point. Secondly, it's the defendant's lawful right to send me an assignment according to the agreement. So it's not an area where I can say, okay, I have been sent to do an assignment there and so on, because I signed the contract which says the employer has the right to relocate or send me an assignment to somewhere else. So I didn't see this a point where we have dispute or illegal. If I thought it was illegal, I should brought it to the court, which is not the case. So I had only responded to it when they brought it. And actually I was very surprised that they were saying he was not even an employee at all for the whole 6 years. Another point also regarding the disclosure of all the relevant and important information before the court, which is the employment case in Sudan. I didn't highlight it because that case is related to an employment subsequent to the expiry of the current employment. This employment ended or expired on the 31st of July 2014, and the employment in Sudan started on the 1st of September 2014. So more than 1 month gap between them. And I have attached my claim in Sudan with a translation, legal translation, and also I have attached the response of Sudatel in Sudan to my claim. If you look at tab 11, page 363,
yes.
This is the translation of my claim in Sudan. I gave a brief and like an introduction to the court over there in Sudan. I highlighted that my grantor worked with the companies or defendant branch in the UAE from 2008 all the way to 2014. So I didn't claim that I worked for Sudatel in 2009 because that was a consultancy assignment. That was an assignment by the defendant to Sudan. Moreover, if we look at the response of Sudatel to my claim in Sudan, I have also translation, legal translation for that. Yes, page 377.
Give me a second.
It's okay, it's all right.
$377.
Yes. This is Sudatel response
To the claim.
to the claim. They mentioned that we recognize the work and deny the date of appointment and remuneration, and we add the plaintiff work for the Expresso telecom group.
Where are you reading? What paragraph?
The last paragraph, second substantive defenses. So work for the Expresso telecom group in the United Arab Emirates from September 2008 to August 2014. So they are confirming that what I said. I have been working for Expresso all the way from 2008 to 2014, and not for Sudatel. Even they said they continued and said, and was appointed to the defendant, which is Sudatel, on 1st of September 2014. And that was the starting of the employment relation. That's what they said, what I have said, and all the documents say. So they are accusing me for working with someone who said that this person never worked for us before 1st of September 2014. The documents say that, everything says that, and the explanation of the assignment, like even they provide the local contract in Sudan, that was the practice of the defendant, because as I mentioned, the company here is administration office. Most of the business is done on the operations. So the practice was, whenever you assign someone to an operation, you sign a local contract so you can pay local expenses and accommodation, etc., in a legal way on that country. You cannot just pay without any. So local expenses, instead of having per diem from Dubai, we used to have local payments in the local currencies in all markets. That was practiced in Sudan, in Mauritania, in Senegal, in Ghana, Nigeria, all the operations of the Defendant. So that's a clarification of why there was an agreement in Sudan, which has never been recognized or considered neither by Sudatel as an employment, nor by myself, and the response of Sudatel is clarifying that. Regarding the travel statement, which I provided, actually I was trying to provide any relevant information, so I was showing that this is the nature of the job, being traveling most of the time. However, I appreciate the work they have done in coming with a summary of the days that I have spent, but those figures are not reflecting the full days, because as I mentioned, I have attached only the travel via Emirates Airlines, because I have like Skywards account, so I can go and look and get all these records, and this is what I have done. However, we used to have other airlines. We used to travel different parts of the world according to the destination. We select different tickets, and sometimes even price affects that, and so on. And I don't have access to those airlines records, so I cannot provide those. So I just provided this to show the example of the level of travel that the job requires. So as you mentioned earlier, I remember you asked about one period from February up to June. Where was he? Those, if I have trips via other airlines, it will not be seen. The only way to get the full record of my stay is to go to the immigration and the department and get that, which is all right. I don't have a problem for that. So I was not hiding, and I actually came out with this statement for the sake of giving more explanation to the defendant and to the court about the nature of the job. The point which they have raised regarding the relocation, first of all, there is a misunderstanding from their side. I have never requested Expresso of the defendant to pay relocation for me from relocation expenses for me from Sudan, from Dubai to Sudan. That never happened. What I have requested exactly is the amount of 40,000 dirhams, which is stated clearly in the first employment agreement. The first employment agreement, I moved from Sudan to UAE according to the employment agreement with Expresso. And that agreement says I should be paid 40,000 one-time relocation for that fixed contract, which didn't happen. I received 4 months' salary, but I didn't receive the relocation allowance, and I didn't receive 7 subsequent months' salaries as well, which I have claimed as well. So I never claimed relocation expenses for Sudan. And actually, I didn't have even per diem for the trips to Sudan, the assignment to Sudan.
And that relocation from Sudan to Dubai?
Yes, for the first time I joined the company.
That's why very sad.
That I should have it, and they didn't pay it, and I just claimed it. So I think they misunderstood the point. And if you look at the agreement, if you look at page. It's in volume 1, tab 3.
143.
Just tab.
What's the close number?
It's tab 3, volume 1, page 24, point 2.3.
Wait, what are you reading again? What is the reference? What is the correct reference now?
It's
Volume 1.
I want to show the relocation, which I requested.
I'm in volume 1 now.
Yeah, in volume 1.
Just give me the page number.
Okay, page number is 24.
24?
Yes. Tab 3, 24.
It's in your bleeding, isn't it?
No, not in the bleeding. I want to show the employment agreement, first employment agreement, which states that I should be paid the relocation allowance of 40,000 dirhams.
Oh yeah, this is the 1st of November 2008 agreement.
Yes.
And what are you reading now?
Yeah, point 2.3. Last
2.3,
line of
yes.
it, a one-time relocation allowance payment of 40,000 dirhams. This is what I requested and I didn't get. And even in the email correspondences, they didn't deny it. And to make sure that I refer to this one, not another relocation allowance, if you go to page, Your Honor, to page 132 of my claim,
Yes.
you will find in the second line, beginning of agreement 1,
Yes.
relocation allowances 40,000 dirhams. And even I mentioned, this is the claimed amount, and this is what they proposed by them. So there is no difference, and I put nil, because there was no initial dispute on that. All this came later on, where everything has been dropped, and a new allegation came up. Yes. And by the way, the defendant never said that I was not an employee until we filed this case. So all the communication since the expiry of the employment until the filing of the case, they have never mentioned that, and even all the email correspondences and calculations were based on employment rights, like gratuity, leave encashment, etc. All of those. Yeah, and never, this consultancy, I don't know how it's right. Okay.
Yes, go on.
I'm almost done regarding the response to the immediate judgment. I just would like to make sure that I respond to all the points that they have raised for the clarity.
Yeah, make sure.
So I have mentioned that the employment agreement are employment agreements, we never consultancy agreement, and since the defendant has drafted consultancy agreement as part of their list of agreements and documents, then that should have been signed in the first place, and that should have been signed later on in 2010 instead of doing a promotion and signing another agreement, and again in 2012. So they are aware of the concept of consultancy agreement and never have been engaged in that one. So it's not like they were not aware and they assumed this employment agreement is a consultancy agreement. They know there is a clear distinction between them. And this is why at a certain point they propose that, and which has not been accepted.
Are you consider yourself a proper employee for the definition of the DIFC employment law? No,
Absolutely. Okay, the defendant also. They claim in one point that I have claimed in Sudan the rights, employment rights in Dubai. It's never the case, and I would like also to highlight the translation of that, which shows exactly what I have requested in Sudan.
So you were not in forum shopping, huh?
Yeah, no, I'm not. We'll try to be precise.
Okay, what is that? Number 11? Tab 11?
Yes, tab 11, yes.
Yes. Is that case settled in Khartoum or not yet?
Not yet. Not yet. Actually, they have done. They requested they have done appeal, which the court rejected, and now we are back again. We have a hearing on the 2nd of October for one of the witnesses that they requested now.
So you filed in 2017?
Yes. Yes. So it's more now. It's more than 2 years now.
Yes.
I want the prayer. Prayer. Yes.
So your submission says that even until 2017 you used to come and work from the DIFC offices.
Sorry.
Your submission says
Yes.
up until 2017 you used to come to Dubai and work from the DIFC offices.
Yes.
On what basis?
From 2014 to 2017, I used to come sometimes for the employer in Sudan Sudatel, because if you have any meeting in UAE, we do the meeting in the offices of Expresso Telecom Group, because it's a subsidiary of Sudatel.
Oh, so the relation between the two
Yeah, the
companies
relation
still exists.
So it's like an office wherever we have anything in Dubai, we come and we meet the people here. And I brought that point to show that I have been in continuous contact, not only by emails, also by face-to-face meetings. Whenever I come from Sudatel for a meeting here, I meet the whole management team and the staff here in Dubai. Up to 2017.
Why you wait such a long time to claim for your
Because, first of all, I have been claiming, I never kept silent. The emails correspondences shows that.
Yeah, I see the emails. I said,
Every year I
you never
highlight
attempt
that.
to come to court, for example.
Yeah, first of all, they promised me that we are going to resolve it. Sometimes they say that, okay, we have cash flow issues. We cannot
This is
pay this year.
substantial money for you. I mean,
It is.
it's a lot of money, isn't it?
It is a substantial money for me. And also, I was an employee of the parent company. So I felt it's not like right that since they tell me like, okay, we are going to resolve it, and I just rushed to the court it's my employer as well. So this is a parent company, and this is the subsidiary. And they were showing good face. They said, okay.
But in Sudan, you run that straight away to the court. Once they terminated you, but for the DIFC one, you have not taken an action.
Yes, because in Sudan, after the termination, I have no any relationship neither with Sudatel nor with Expresso. So there is no issue of having this kind of employer relationship. Another part, in Sudan, when they have done the termination, because this is the first time to terminate my employment. I have never been terminated in my life, anywhere. Even with Expresso, I have never been terminated. The contract came to end, and then I moved to another employment with Sudatel. So when they terminated the contract, I knew that they don't have good intention. This is my feeling. And the only way to get my rights is to go to the court. And this is why I went to the court in Sudan in 2017. Early 2018, I have sent a notice to the office here in Dubai as well for Expresso, because I felt what used to be said, like, okay, we are going to resolve it, just give us time, we need to secure cash flow and so on, because it's hard currency. I felt that was like just wasting time. And then that was the time where I decided to go to the court, because that was the only option left for me.
So you wanted to show me what you exactly, what kind of remedy you have sought before the court of Sudan.
Yes, I'm not finding the translation, unfortunately. So because we have like several. We have done a claim and then we had to modify the claim. So I want to show you exactly what I have requested. It's mentioned that to pay, if you look at page 367,
Yes.
upon which my grantor request the Honorable Court.
Can you see? If you see,
Sorry?
you see the sub-numbering C, the defendant paid the entitlement.
Yes,
of my-
yes,
yeah,
exactly.
During the previous period.
In accordance with the provisions of the labor law.
Yeah, but you're not defining the
Yeah, but-
previous period.
I defined that in the beginning.
Defined at the beginning?
At the beginning, I mentioned that if you look at point number 2, point number 1, sorry, at the last of the page, end of the page, the
Yes.
plaintiff works with the defendant as the director of planning sector since September 2014.
I see.
So that's my claim. And I put for further information where I mentioned that my grantor worked with the company branch in Dubai from 2008 to 2014. So my employment I refer to is only September 2014. I have never referred to the employment of 2009 because it was consultancy and it was not employment. It was assignment, not employment.
Again, there is no much of detail even in your pleading before the Sudanese court.
There is another one, but
So it's like a habit for you, Mr. Musaab. You didn't put a lot of details before court
No, I put
until
actually-
you ask about by the judge or something.
No, actually, I put on the another one, but I have attached only this one to show the time period because the main
So
issue
it's
is
not the detailed one. You mean.
no, there is
This
another
is
one.
not the particular one.
Yeah,
This is
no,
the
no.
claim form only.
No, there is another one where we have all the claim required, all the
Details.
pay. I have the whole pay where I said, okay, to pay the salaries from X to Y.
It's not attached in here.
No, it's not attached because when I brought this, I brought it as a response to what they mentioned that there is a case in Sudan and I have requested the rights of my work period in Expresso to be paid by Sudatel and they said, I want to get money twice. So at that time I responded and I brought this relevant document showing that I have never requested anything before September 2014 in Sudan. And I provided that Sudatel confirmed that I have never worked for Sudatel before 2014 September.
Yes. Right.
So that one, the details, I thought they are not relevant because this is why I didn't attach them. The defendant mentioned that there is no real prospect of succeeding on this claim. Although we see that, or I see that, there is very strong prospect of succeeding based on all the facts that we provided, based on the signed employment agreements, based on the fulfillment of the employer-employee relationship, all the conditions and so on. Even the time barrier, we consider since these employment agreements were consecutive and this employment period is continuous, there is no way to claim gratuity or end of service for first contract or second contract because the calculation and the formula itself, it depends on the duration of the employment. So if the employment is less than 5 years, it's different from less than 10 years, different and so on. So the end of service entitlements and gratuity becomes due at the end of the employment for the whole employment period. So no way that first employment or the rights related to the first employment and second employment agreement has become time barred because the end of service for both of them becomes due on the 31st of July 2014, which is less than 5 years. They mentioned another point. They said that according to the law and UK law and common law, etc., and they brought some cases and references saying that the defendant did not exercise sufficient control over the claimant, which is absolutely the opposite. The claimant, according to the defendant, according to their admission, that they instructed me and relocated or shifted, they use different words, from Dubai to Sudan, according to the agreements. All the trouble trips and business trips were for the defendant. And they even never denied. They never said, oh, those were like, have been done by the claimant without our knowledge, or were like, it was not to the office. So all those are very expensive business class trips. If you look at them, it's a hell of money.
Yeah.
They have been paying all of that. And actually have been managing hundreds of millions of dollars of investment of the group. Have been managing a huge investment on submarine cable, have been managing all the networks in those countries. It's really a very critical business. Hundreds of millions. It's not like small investment. And this is why they are paying all this amount of travel expenses and salaries and so on. So no way to say that this is not unemployment.
Anything? Can you check the AC? I think it's a bit hot.
They mentioned that the claimant used to sometimes to come to Dubai without a court office, which never happened. As I have mentioned, I didn't even took any leave. I was always reporting to the office. I used to leave sometimes even after 10 o'clock, and that was very often because of the time difference between UAE and the operations in West Africa. Most of our operations in West Africa, they are on GMT zone. So we have 4 hours difference, and the work there ends at 6 o'clock. Their time, which is 10 o'clock UAE time. So I don't know how they say that. I used to come and not report to the office. Another point regarding the absence, which they raised, if this absence was not relevant to work, or not,
Do you have anything in your evidence that shows that you've been working really from the DIFC? Do you have anything in your...
I have the visa, employment visa, of course. I have several certificates. I have the medical insurance card.
No, I said that you came physically to the DIFC offices.
I came physically to the DIFC office after 2012.
Yeah.
After the...
Till 2014.
Not fully, because end of 2013, I got another assignment in Sudan for like 7 or 8 months. So, but still, I used to come and then go back to...
Yeah.
And whenever I come to the DIFC office.
Yes.
That's what's the bit. Regarding the absence, what I would like to say, if that huge absence was not related to the work or business missions, then the defendant should have taken legal actions and terminated lawfully, in that case, the agreement, the first agreement, and again the second agreement, and the third agreement. How comes you keep renewing the contracts or signing new contracts, pay salaries consistently without any deductions?
I don't recall they said you've been in absence. They said you're on consultancy basis. I mean, that is, I think what Mr. Hussein tried to make it clear. You're on consultancy basis. It was acceptable for them. Like you come sometimes to Dubai, but most of the time outside the DFC, but it's not an employment matter. That's what he said. I didn't recall. You didn't say he was absent, isn't it, Mr. Hussein? I don't recall it.
No, Your Honor, I did not say absent because absent would mean he's an employer.
Yeah.
Employee.
Yeah.
I said that he was, whenever he was required, he was needed.
Yeah, I see.
Actually, they said if the court considered the claimant as an employee,
Yeah.
in that case, they mentioned, in that case, the absence should be enough for the defendant to terminate the agreement. And he said that even today, in the hearing, and he said, which didn't happen, but he said they have the right. So they put that as a condition. If the court considered this employment relationship as an employment, then they say that, okay, that was absence. So I can find even the clause. If you look at the...
Well, they can't anyway. I mean, they can't, take this retrospectively, so they can't come and terminate you now because you've been absent like 6 years ago. Or 5
And
years
even signing new contracts, contract after contract, without even promotion.
And you say
even
that
consistent.
you say that is a waiver and you relied on it. That's what you're saying.
No, of course. I'm saying that I was never absent. I was on business trips for the defendant. And this is why it has never been considered by the defendant as absence. That's what I'm saying. Because it cannot be like an international company, a group, such a group, international group like Expresso Telecom, where people keep absent for hundreds of days every year, as what they show, without taking an action.
They get promotion instead.
And you get promotion, even no deductions from salaries, even new agreements are signed and promotions and so on. So it doesn't make sense for me. Regarding the point of working from or within the DIFC, we have covered some explanation from what we understood from the law, and that the law mentioned within and from. It didn't say just from. It put two options because they are totally different: to work from or to work within. So to work within is physically within, this is what I understood, from the premises of the DIFC or the territories of the DIFC. From is to work through a company registered and licensed in the DIFC, which is also the case. And even the employment agreements mention that the employer is Expresso Telecom Group, a registered DIFC company with an office address at 7 Jumel Towers. So they never mentioned at that time because they didn't have an office ready at that time. Their office is in JLP. That's what they mentioned. So this is still, actually this confirms that I was an employee of the defendant, according to the DIFC law, according to the employment agreements, and according to the definition itself in the law. Because otherwise the court would have said only within the DIFC. And at the end we leave this for the Honorable Court to decide on the meaning of this definition. I think that's all, Your Honor, regarding the responsible immediate journal application. And I seek the Honorable Court to dismiss this application for the sake of justice, for the actually in line also with the evidences and clarification provided today. Thank you very much.
Thank you. I might come back to you later, Musaab.
That's fine.
Mr. Hussein, you have some comments to make on Mr. Musaab's submission?
Yes, Your Honor. I have actually several small comments.
If it's small, I don't mind.
Your Honor, first and foremost, as this Honorable Court may have noticed, all these things which are coming before this Honorable Court are not contained in this particulars of claim. I did not get an opportunity to discuss each of those points in my statement of defense. However, there were documents which were widely arranged in this. Before I go to my submissions, I want, since the claimant is arguing in person and is not assisted by a counsel at this time, I would like the court to inform the counsel, to inform the claimant that any submission made to this court today, if found to be incorrect, has legal consequences. Because everything that we write and say is supported by a statement of truth.
The claimant reminded so.
Thank you. Your Honor, I want to bring to your attention now several small points which are very critical in this case. Sudatel, which is a company in Sudan, as the claimant pointed out, is the, it has a wholly owned subsidiary, which is in DIFC by the name Expresso. Two are totally different entities. The operations, everything is different, that's why they're subsidiaries and not a branch. This is an important point. Two different legal entities, a subsidiary but not a branch. Now, one of the things that the claimant appears to have first time brought to the attention of the court is that he said that he used to work for the subsidiary in Dubai. But if you look at his claim, which he pointed out, where I want to bring the attention of this honorable court to. He referred to the documents, which is page 361 and 377 of volume 2, in which the term of employment was referred to as 2014. What we had visited earlier, what he did not inform
Oh,
us.
sorry, what documents again? Remind me.
Yes, Your Honor.
361.
This is tab 11,
Yes.
page 361.
Yes. The visa.
Yes, Your Honor. I think it is page 363, Your Honor. And at page number
363 is bleeding before Sudan court.
Yes. Now, if you see the date of this pleading, which is at the end, at page 368.
3rd of August 2017.
Yes, Your Honor.
Yes.
Now, in this, the claimant referred to paragraph 2 and requested you to read. My grantor worked with the company's defendant branch.
My grantor mean my client, isn't it?
Yes. From 2008 to 2014, and it has unpaid entitlements. So this is what he brought your attention, and he was working. He has submitted that he worked in Dubai from 2008 until 2014. Now,
But see, in number 1, he said clearly the plaintiff works with the defendant, so he named them the defendant. I can see something here. In number 2, work with the company, then the defendant, a branch
The company's branch.
in the United Arab Emirates. Okay, so your problem with the identification of branch or subsidiaries?
Your Honor, I am not, the translation is not correct. We need to look into the translation. But the
If you
point-
allow me, I can look at it, yes.
Yes, Your Honor.
Yeah, it says branch. UAE branch, you said.
Yes. Because it's fully owned by the Sudan branch.
So, Sudatel is the mother company, isn't it?
Yes. Yes.
I thought Musa Hussein was saying Expresso is the holding, and then Sudanese comes
No,
below.
Sudatel is the holding. Sudatel is the 100% company.
It is the mother company,
Yes,
and Expresso is one of its subsidiaries.
that is correct.
I see. Yeah, I see. But I completely understood the other way around from your submission. Maybe I got you wrong, maybe, but that's what I understood is Expresso at top,
No.
and then Sudatel is. I see.
As the learned claimant explained.
No worry.
Yeah.
No, okay, so he was referring to as branch.
Yes, Your Honor, but it's not a branch. It is
Maybe under Sudan law.
right, Your Honor.
I don't know. Okay, go on. What is the submission you want to make?
Yes, Your Honor. Now I want you to look into volume 1, tab 10.
But let's stop here and say he is making two different points. Is that he worked with the defendant from 2014, and then he worked with the defendant's branch between 8 and 14. Although he said he still has unpaid entitlement.
Your Honor, since he has relied on this to show to the court that he was, in effect, an employee of the Dubai company and not an employee of the Sudan company. So therefore, what he did not bring to the attention of this honorable court, when he showed this document to this honorable court.
What document you want to show?
Yes, this is page 270, volume 1, tab 10. Page 278.
$78.
Page 270.
We have looked at this earlier.
Your Honor, I brought this to your attention in the beginning itself. We read it together.
Labor Court of Khartoum, amended statement of claim. Yeah.
This is an amendment that we brought subsequently, and in this amendment, it's very important to see what's written. My agent, the claimant, was working with the defendant since September 2008 up to May 2017.
Yes. Go on.
So, Your Honor, my learned client did not bring this point to the attention of the Honorable Court. And he referred to an earlier link. This is an amendment to the claim. And Your Honor, I want to take you to the next page because a very important question was asked by the court with regard to this. After this, if you go to the next page, page 279. If, as the claimant submits, that he was employed by the Dubai company as a full-time employee, then if you look into the reliefs that he is claiming, I would like to draw your attention to 9, A, B, C, and D. I want to read this, Your Honor.
Go on.
The claimant kindly requests Your Honor to court, this is in Sudan, to judge for him with the following: a compensation for the arbitrary termination of services, so and so.
Yeah.
Unpaid salaries to the total amount of so and so. Entitlement of salary for assigning the duties of director of network sector, so and so. End of service gratuity. Why is he claiming end of service gratuity there? For this period. Attorney fees as agreed, and the lawful suit fees. Isn't it true that the claimant is claiming identical reliefs from the parent company as well as from its subsidiary in Dubai? Identical reliefs as an employee? I think at some stage there should be an election. Claimant must decide, is it going to claim these reliefs in Sudan or is it going to claim these reliefs in Dubai? Now, if it has claimed, as we can see from the submission, these reliefs have already been claimed in Sudan. So the claimant is now prevented from, in another forum, to claim the same reliefs that it has claimed earlier. This is the point, Your Honor, I wanted to bring to the attention of this Honorable Court with regard to this issue.
I agree, because in number 8, when he mentioned service gratuity, he did not, specify the time.
Yes, sir.
He's looking for this.
You know me, Your Honor?
Would you please explain?
Yes, thank you very much. Actually, I was trying earlier to find this summary. I couldn't find it. Although this one has been filed by them and not legally translated. However, I would like to clarify. If you look at the first request, point number 9, the claimant kindly requests Your Honorable Court to judge for him with the following.
Yeah.
A compensation for the arbitrary termination of services, which occurred actually, if you look at the previous page, which occurred in May 2017 for the employment in Sudan. It has nothing to do with UAE or the defendant. Second point, unpaid salaries of total amount of 153,290 SDG.
This is explained in number 6, I guess.
Yeah, exactly. So we need to read them together. Unfortunately, he didn't show that. The details are mentioned there. Unpaid salaries are related to the period from August 2016 to May 2017. Has nothing to do with the period of employment with Expresso. Again, entitlement of salaries for assigning the duties of director of network sector of this amount. This also related to the point number 7. And you will see the claimant is entitled for assigning him with additional job duties. Actually, I just handled 2 roles at the same time. Yeah. And the second role was assigned to me from the 9th of August 2015 until September 2016, which is also beyond the employment period with
the important point is D. Go on. Yes.
Then the gratuity, which is the point, you are right, the dates are not mentioned. However, there was a table filed in the court, before the court of Sudan, showing each item and the calculations for that, and the basis of the calculation as well. And the end of service gratuity, according to my calculation and to the hearing of the witnesses in Sudan, including the HR director of the company, Sudan, before the court, he mentioned, and we calculated based on the company regulations, the end of service gratuity is like 4 months for each year of employment, and I calculated that based on employment periods from 2014 to 2017, which gives you 36.
I know this number is significantly smaller than the number you're claiming in this claim.
It's totally irrelevant. So it's mainly 12 months entitlement for end of service according to the company regulations in Sudan. So I have to request my end of service in Sudan because there was unemployment in
So
Sudan.
how much was your salary, annual, so your monthly salary?
was, if you look at the previous page, you find my salary,
Yeah.
$5,000 plus 36,000 SDG, which was equivalent like to $4,000 or $5,000 as well. So in total, like $10,000. So when I calculated the end of service gratuity for the period from 2014 to 2017, for each year, I am entitled to 4 months salary, which gives me 12 months salary for the 3 years. And if you multiply,
That should be 40,000, isn't it?
sorry,
That should be 40,000 US dollar maybe. How gratuity calculated in Sudanese law, do you understand?
at that time, when I started
1 month per
contracting,
year or how it works?
in 2014, the exchange rate was like 9 between SDG and dollar. Nowadays, it's like 60 plus, 65 or something like this. So there's huge deterioration. Okay.
And I said, how the gratuity calculated? Do you receive like 1 month salary per year or how?
Now, I
it works?
receive executives, top management of the company, they receive 4 months salary for each year. And even they, because it's a special contract, even it's not necessary to consume like 3 years or 5 years and so on. The company regulation says,
Yeah.
even if it's 1 year only, you get 4 months end of service gratuity. So for 3 years, from 2014 to 2017, I was entitled almost to 12 or 11 months because the third year was not in full. So I calculated pro rata and I came out with like 11 months.
Yeah.
This is my entitlement for the like 33 months or 32 months, less than 3 years a little bit. And it gives me 11 months. When we multiply 11 months by $5,000, it gives us $55,000, which you see here.
Okay.
And when we multiply the 36,000 by 11, it gives you 396,000. So it has nothing to do with anything else.
Okay. Ms. Hassan, yes?
Yes, sir. Your Honor, if you go back.
Well, let's see, because the number are much smaller, and I think
Your Honor,
that would it.
the difficulty that we are dealing
See, I'll tell you what I'm doing here. I don't want to call this as a mini trial, you know what I mean? My job is here in trying to see the claimant have a realistic prospect to win if he proceed to trial, you know what I mean? I'm not deciding this case completely. I'm deciding your application. This guy got no real prospect to win, you know what I mean? But so because I am in between deciding the case and deciding the application, I can't go to this exact figure and say yes, this is he was claiming the same figure here and there. So don't spend much time arguing this. You go on with your another point, Mr. Singh.
Yes, sir.
Okay.
Thank you, Your Honor. Your Honor, the second point was with regard to the visa. A visa page was shown to the court. Your Honor, without going into the details, if we go, we notice that on the visa, it's written, visa is issued from 2013 to 2016. So what about if he was an employee of the PIC? What about from 2008 until 2014, until this relevant date? And what happened after, between 2013 to 2016? The point is, as this Honorable Court had posed this question, this visa, as the claimant said, that he had to travel because of from Dubai for several meetings, and he used to have the meetings at the Expresso office. So it was for the purposes of, as he seemed to argue, it was for the purpose of convenience that this visa was issued to facilitate it easier for him to come and go as and when he pleases, as opposed to the previous process of going through the rigorous application. So if this was simply an arrangement, is it not true that since he was working with the parent company, and as we have seen at page 271 of the same document which you have in your hand, where his salaries from Sudatel are mentioned, which this Honorable Court saw in the beginning. This is tab 10, page 271. Your Honor, there are salaries mentioned here also. You can see that there is a 31st 10 2009, 31st 10 2009. So there are salaries mentioned here, 2009, 2010. So he has been drawing salaries from Sudatel also, from the parent company also. So drawing salaries from the parent company. drawing salaries from the UFC company, which of these two is an employment contract? Naturally, there cannot be two employment contracts for the same time period.
Yeah.
Your Honor, may I
Maybe you
clarify?
can. No, I will come back to you. Okay? Write this note down and then you explain to me how you receive two salaries. Okay. Yes, Mr. Singh.
Your Honor, next point is, a point was brought to the attention of this Honorable Court that this case has been concluded in Khartoum. As to the best of our knowledge, when we inquired from our clients what is the current position, we have been given to understand, and I'm subject to what I have been given to understand, that this appeal is still pending in Khartoum. This is what I have been told.
Yeah.
So the court has not finally adjudicated on this matter in respect of the claims that he's making before this Honorable Court. I think it is very important for this court to also take note of this fact that either this court should keep its proceedings in abeyance, this immediate judgment application abeyance, until it is able to find out what happens in that case, and that judgment is produced before the court, so that we can see that there is no duplication of what is being claimed there as well as what is being claimed here. Either this is something which court may want to consider. Should this be a consideration relevant to the court's determination?
So this is in your very last alternative argument that this court should stay the proceeding until the Court of Sudan finalizes the Court of Appeal.
Your Honor, in fact, my
This is a new
application
prayer.
is for- and-
This is a new prayer, Mr. Singh.
Your Honor, this is definitely an alternative. Absolutely a new prayer. But not in my submissions. Because there are a lot of new points, Your Honor, which have emerged today.
Well, I think, you should expect always new things when you have litigate in person, Mr. Singh. I'm sure you're familiar with this.
Yes, sir.
Well, yes.
No, Your Honor, that's a very relevant point, and Your Honor, you're absolutely, I take your point on that. Your Honor.
But that doesn't make the court in favor of one party. If one party is not assisted, that the court shouldn't be.
Not at all.
Shouldn't be partial as well.
Your Honor, after all, our job is to place the facts before the Honorable Court. And in this, Your Honor, since you are going to make a very important determination today with regard to whether there is any ground to allow this immediate judgment application. So I want to raise one more point, which is, and question was raised on relocation allowance. And they said we claim relocation from Khartoum to Dubai. In fact, I would accompany big relocation allowance if it comes from Khartoum to Dubai when you were working in Khartoum during that period and not in Dubai.
I don't know. You ask your company. They drafted the contract, Mr. Hussein.
Your Honor, but it does not say that this is for relocation from Khartoum to Dubai.
What is it?
The relocation is from Dubai to Khartoum, to moving from here to some other place.
So who moving him now? Is it Expresso moving him? And he got a contract with your firm, isn't it? The contract is signed between Mr. Musaab and Expresso, and the contract provides for relocation. If we say he just relocated to Dubai because of this signing.
Your Honor, if he relocated to Dubai, if he worked in Dubai, there is no employment contract since 2008 that covers the first employment contract or the second employment contract.
Well, I tell you what, this is really can be read either way. I do admit. However, then the burden, I think, in your side now to tell me, because you, the party, drafted the contract. You, the parties, put the contract before the claimant, and then it's a duty to tell me what does the rest, or at least to indicate in the contract what you meant by relocation, and when the allowances are payable.
Your Honor,
Explain.
clearly relocation in this context would not mean that he is relocating to Dubai. He is claiming the relocation allowance. Actually, the party that is claiming the relocation allowance has the burden of proving on what grounds he is claiming relocation. Now, as per the rules, since he is alleging this point, a claim is made by him.
But he said, I either relocated from Sudan to Dubai or from Dubai to Sudan, and then you tell me, well, which one you choose. You pick one. You
Your
said.
Honor, that's why we did not consider this relocation claim at all, because this relocation claim would only have been if we had relocated him. If he had come to work with us in Dubai, then would have been.
This did not exist in the second contract, right?
Your Honor,
No relocation in the second contract? Is it in all of the contract?
Your Honor, the first three pages.
I know I've seen the first contract.
Yes,
That
sir.
is the 2008.
The second contract as well, Your Honor. Just to
Check.
and it has not been, Your Honor, it has not further, if you look at the particulars of claim, nowhere has he pleaded that he has. Your Honor, pleadings are very important. Today, I find myself in a difficulty in responding.
That's why he's asking for amendment of a bleeding Musa. Saying, so you should agree with him. He wants to make himself clear. Are you denying that now?
In the amendment, Your Honor, that he has made, the proposed draft, he has not asked for this relocation cost. He has not claimed that, he has not substantiated again in the draft particulars of.
Then it's not important. We shouldn't discuss that.
No, Your Honor, I agree.
If it's not in his remedy anymore, that's it. So he's a generous guy now.
Now, Your Honor, I want to finish these 2 points and then come to my last point, which I want to
Please.
bring to the attention of
Please.
the court. The point is that he asked for that we have always paid his airfares. The answer is that we have not always paid his airfares. If you see, he has also raised some small claims with regard to Expresso did not always pay his airfares. The third last point that he mentioned was office in GLT. Where there was shortage of space in DRC with the permission of the DRC authority, the leasing authority. Some companies which were not able to find a place were allowed by law to work outside, and that was as working within DRC until such time that the place became available in DRC. When the place became available in DRC, they moved into DRC.
And now you're arguing in favor of his own submission.
No, Your Honor, not in the favor of his own submission, because all I was saying is that everything has to be understood and read in the context of Article 4. And it was in the context of Article 4 that I wanted to argue that he also referred to one point in the employment contract where party could move him, where we could move him anywhere.
Yeah.
But the point is, it does not say move anywhere outside the building. It does not mention we can move him, it mentions within, wherever we want, if we want it. But we did not exercise that choice. What he has not shown to the court, that we exercise that choice. So reference to that particular point is not relevant because the burden of proof is on him to plead his claim. This cannot be an opportunity for him to improve upon this claim. Again, I'm mindful of the fact as is on the.
Well, actually, I do not accept this argument at all. And I'll tell you why. Because you're trying to define anywhere by your own term. Anywhere means anywhere. Anywhere never have a border. Unless you want to put a border, you should have done so. If you want anywhere to be limited, then you should have limited it in your contract.
Your Honor,
the original situation, from language and then from legal point of view, anywhere doesn't have any border, it has no limitation. Unless you have intended to do so, you have not done so. Then how you want him to make to? How you want me or yourself to say? Where else or anywhere means Dubai.
Your Honor, naturally, if it would mean anywhere, he could be, then there should have been a secondment agreement.
It can be another planet even. It can be another planet, Mr. Hussein.
Yes.
You can send him to Mars if he says anywhere. Then we say, if you want to tell someone you go anywhere, that it means anywhere.
Your Honor, that is clearly not written in the contract. But yes, I take your point that in the absence of such an important thing, it can be interpreted as this honorable court is very rightly pointing out. So definitely this is not a point that I would like to.
It's not a big point. Yes, it's not very important anyway.
It's not a big point.
But I just wanted.
Your Honor, to sum up, where we left last was Your Honor raised a very important point that the new law, assuming if it were to apply, because that is a very important consideration.
Well, believe me, when I went to my room, I read it 10 times. I could not understand it.
Your Honor, I tried to do, because before coming to this court, I tried to look into almost, if there is any commentary, I looked into 6 law firms, what they wrote, but none of them addressed the most critical point. Perhaps, if you listen clearly out for 5
But
minutes.
maybe after this case.
Your Honor, even for an academic value, if Your Honor will allow me this very important point, because I went through something in the break, and my team actually, my colleagues here, who have more knowledge than myself on the subject, who have gone through this in extreme detail, asked me to bring a few important points to the attention of this honorable court.
Please,
if this honorable court deems it proper, with your permission, Your Honor, I want to bring to your attention three important things. Your Honor, we both you and I, this honorable court mentioned that it appears to be a harsh provision for the law to apply retrospectively, and all the cases that existed or were continuing to be affected by them. And I shared the sentiment, and I said, Your Honor, I can't agree more. And this was my feeling. But Your Honor, when what I did was I opened a consultation paper, because the procedure when the law comes into the FCE, consultation paper that is issued. And in this regard, Your Honor, may I draw the attention of this honorable court to volume 2, volume authorities bundle.
Yep.
Authorities bundle. And Your Honor, at page 213.
Tab number 5, 6?
This is Your Honor, tab number 15.
15.
Yes, Your Honor.
Yes.
Now, Your Honor, if you look into the nature of the claims, those three claims, what are those? Those claims are, in effect, the penalties for terminating the employment and not paying the employee the relevant dues, and then there's a penalty on the employer per day, the last drawn day, until the claim is filed.
Yes.
So that was the issue that came up before the lawmakers in the UAE. And at paragraph 39 of page 213, it says, Your Honor, one of the more contentious provisions of the current law is the imposition of a financial penalty on an employer equal to the last daily wage of an employee for each day the employer was in errors, with a payment of an employee's dues at the termination of employment under Article 18.2 of the current law. So this was the position, Your Honor, imposition of a penalty on the employer based on the last wage. So even if I file my case after 5 years, 11 months, I'm still within limitation. And he has to pay, and the employer has to pay 5 years, 11 months salary under the date the case is filed. And if you read paragraph 14, the mandatory nature of this penalty was criticized in several court decisions, as well in the submissions made by the DIFC, by establishments in the DIFC, especially in instances where the imposition of such a penalty was clearly unreasonable. Your Honor will recall, there are several DIFC cases, and I can bring one of those cases to your attention, where, Your Honor, the issue was, should we apply Article 18? Should the judge apply Article 18 selectively, depending on the case by case, or judge had no discretion? The court concluded, we are afraid Article 18 is mandatory. The penalty under Article 18 is mandatory. The judge has no discretion to exercise its discretion and say this is not paid, the judge must pay it. So, Your Honor, this was the reason why this amendment came into being. Your Honor, the judgment I was referring to is the frontline judgment, and this is tab 14 of the same thing, page 202. Now, if you look at this judgment, the last paragraph, this is written by this honorable court. In fact, Justice Madhani has written this paragraph 34.
What are you referring to? Sorry, I'm lost now.
Your Honor, I just want to drive home the point that the provision that we are referring to, that this law has retrospective application. The reason why it is not harsh is because if you look into the statement of objects and reasons for the new law that came into force, the idea was to create a sort of an equality between the DFC laws as they apply to employers, DFC laws as they apply to the employees, and to promote the general interests of the DIFC. So, given this scenario, my submission before this honorable court, relying on Article 1 of that submission, is that this law has retrospective application because this, what does Article 10, the limitation that we just read together, Your Honor, in Article 10 mean? Article 10 says the judge shall not consider. The word used is shall not consider So there is no discretion with the judge to think on its own, to exercise its discretion. But if you look into Article 38 of the DIFC Code law, and Your Honor, if you look into the Article 22 of the damages and remedies, Your Honor, the word there is that claimant cannot commence the claim. So the discretion, so there is some element of discretion there. But here, the lawmakers wanted to make it so stringent, so strong, so harsh, that this particular law would apply retrospectively, even to those pending suits, such as in the present case. And if this law were to apply, two things are going to happen. First, the limitation sets in, and even for the sake of an argument.
Yeah, but excuse me, but that is something else. What you just read for me, like from paragraph 39, allowing the court discretion in imposing these financial penalties, this is something else. Because I know Article 18 got amendment,
yes,
and the court now got discretion for new cases. And now the discussion I had with you earlier is whether can this be applied retrospectively.
Your Honor, the reason it is applied
And I said no, because I thought all cases that will not be subject of the retrospectivity, you know what I mean? That is the conflict between me. Can cases that filed and decided in a court can be looked at again? I said no way. Can a case that filed before this court, before the time of this law, can be subject of the new law? That's what I think. And I said that's why it would be harsh. I'm not saying if it's wrong or no, because I can't. If I say it wrong or no, I'm deciding the case before I reserve. You know what I mean? But I said that's why I said it would be really harsh. And my reading, and I tell you what is this is my initial reading. To be very clear with you, my initial reading to this is that the repeal and the replacement under this article shall not affect any right, remedy, dates, obligation occurred or incurred by any person or any legal proceeding commenced under the previous law. And any such legal proceeding must be instituted, continued, or enforced, including any penalty, fine, or forfeiture. And then the problem here comes after the comma. It says under this law. You know what I mean? This is what's making some of kind of confusing before me. He said.
Yes, Your Honor. Your Honor, it is indeed very confusing. But Your Honor, if you read it with, if I read it just for paragraph 3 once again, where you left, Your Honor.
Yeah.
Paragraph 3 says, without limiting the generality of one thing. Clause 1, subclause 2. Now, clause 1, subclause 2 is, whatever happened, it shall be treated as if it happened under the new law. This is what one clause, subclause 1, subclause 2 is. Now it says, without limiting the generality of 1, subclause 2, and subject only to Article 14, 15, 10, and 61(2), the repeal and replacement under Article 1(1) shall not affect. Now, Your Honor, the word there is and subject only to. The word is subject only to Article 10. Now, Article 10, very clearly, the legislators would not have to use the word subject only to Article 10. Because subject only to Article 10 means that the limitation under Article 10 shall set in. It shall act as a bar.
As I said, if you write, and then even Article 10 can be applied retrospectively to cases that been going on under the previous law, which is hundreds and thousands of cases maybe, then we are in a big problem.
The continuing cases, Your Honor, the cases which have not been decided.
Well, they said you can't, not been decided, but it's been, I don't know what to say, but it's, and that's what I thought, it's any legal proceeding commenced or to be commenced in respect of any such right, remedy, dates, or obligation. You know what I mean? I don't know, I think this is...
Your Honor, I think this requires a little bit of more elaboration from, and if this court were to allow this application today, and grant them the opportunity to amend, in such a case, I think there will be an opportunity to comment on this in greater detail.
Key changes. I don't know. I'm trying to see if this consultation paper addresses the Article 1 or not.
Consultation paper?
Behind tab 15. I'm trying to see if they did.
Another important point is the draft law, which the claimant has relied upon. If you look at the draft law, it did not have a limitation period. But when the new law came in, it came in with a limitation period. The draft law did not even mention Article 10. And draft law, Article 10, was a waiver provision.
I don't know. I'll make my finding and I'll let you know.
Yes, Your Honor. And if it's possible, Your Honor, if I could, on the basis of an academic discussion, also present a small note unrelated to the case.
Please.
Now, Your Honor, to conclude on this point, I have already made my points, I will not repeat them. If this court, first and immediate application, this case does not disclose a cause of action and it must be dismissed. However, if the court feels that it wants to grant the other party an opportunity to present its detailed statement of claim in such an event as per the rules of procedure, I am entitled to all the costs as on this date. And those costs have to be paid and must be paid because before they are able to file their amendment to the statement of case.
And on what basis? I mean, I would say Mr. Musaab has admitted he have made maybe wrong reference to the law. But you have brought your application in another certain ground because and that's why you'll be losing like.
Your Honor, if we go into the particulars of claim application in detail, you will see that it was not made in.
See, if you not succeeded in limitation of claim, if you not succeeded in shopping, on forum shopping, if you're not succeeding in what? Remind me your point of.
Your Honor, first was no cause of action.
No cause of action.
Yeah, no cause of action. Second was
because
not an employee. So
it's not an employee, yeah.
The FC law does not apply. Third was limitation.
What if you lose your application after all of this kind of argument? I mean, it would be then very harsh to claimants to bear your cost. Yes. It's a risk I think you taking. I don't know.
Your Honor, this is an important.
It's not easy. I see you. I notice your submission, but I'm just also again discussing this with you.
Your Honor, I was facing exactly the same question.
I'm thinking loud only. How difficult is that? Will be.
And I have made repeated pleas before. This
you better win, Mr. Hussain.
Your Honor, after all, if a frivolous claim is filed before the court, and in our opinion, of course not in the opinion of the claimant, with all due respect to it, and if the claim does not disclose a cause of action, and if the pleadings have not been pleaded with particularity, if the provisions of the law have not been clearly set out, clearly there is not one or two or three errors, there are several errors which need to be corrected. It is as if filing the claim afresh. So which means everything that happened till now goes away out of the window. And what comes in is a new claim altogether. So there has to be there is a provision in RDC which says that the costs 18.27 of the RDC, if I may, with the permission of this court, refer to 18.27.
If you insist, Mr. Hussain.
Yes, Your Honor, I will be I will put to very difficult hardship if this does not happen.
Tell me what's the article 6.
Your Honor, 18.27.
Yes.
A party applying for an amendment will usually be responsible for the costs of and arising from the amendment.
You're reading 18.4?
18.27, Your Honor.
27, sir. Yes.
Your Honor, but the court will have regard to any failure of a party to consent to an amendment in accordance with Rule 18.12. And now, Your Honor, I want to take you to 18.12.
Yes.
Your Honor, in 18.12, it has been very clearly stated that questions of amendment and consequential amendment should, wherever possible, be dealt with by consent. A party should consent to a proposed amendment unless it has substantial grounds for objecting to it. Your Honor, I am making this statement on oath under this court that we will not approach.
I made it very clear to you, Professor Hussain, like 3 minutes ago. If your point is only about the amendment, that I would look at it from different angle. But I'm saying your submission based in various points. You know what I mean? You could I understand you could have brought your immediate judgment application under unfounded reference of law, for example. That's one thing. So then if you stop, and then he come and admits, oh yeah, this is really wrong law, then I'm in favor of allowing him to go through, so I might make balance or proportionate decision about cost. But then if you come and make a bit more advanced application with a different grounds.
Your Honor, I have deleted this point. It's written in my relief. This point that I am stating.
It's one of your points. I agree. It's only one of your points. Then I need to be proportionate also to your application. As I said, I have two applications. I might grant the amendment in his own cost, but I might refuse your application in your own cost. That can be another thing. Or I might make an overall, proportionate cost order, for example. You know what I mean? I don't know, because I want to see what direction I'm going. I have not made my mind yet about where I'm going, but we usually try to make a proportionate. Proportionate mean, you understand, the grounds you bring in, the number of arguments, the way you defended the claim, to what extent your argument really did make sense or not. So little thing will be taken into account at the court time as well. For example, if you have just contested the amendment application, we would finish by 11 o'clock in the morning. So that is another level of course, isn't it? But because you brought another ground, and you ask even the claimant to defend the ground you came up with, you just made him a good lawyer today to defend your claim. And that's something need to be really considered.
Yes, sir.
That's all. Okay, thank you. I might come back to you later. Mr. Musaab, if there is anything you want to make.
Yes, I would like just to comment on the points raised by the defendant. First of all, regarding that new items or new evidence is provided today. Actually, nothing new. All what we have mentioned has been included in the submissions in our particular claims, as well as the reply to the defense and so on. We never brought anything new. All the evidence were there. All the information was there. We have just done clarification, and the amendment is seeking the correction with regards to the law and some miscalculations. Without giving effect to the evidences we traced earlier. Another part regarding the relocation allowance, because he mentioned that the relocation was not clearly stated and so on. We showed that.
He said it means.
I would like to highlight the exact word mentioned in the agreement.
Yes.
It mentioned that the employee agrees that he may be required from time to time to perform certain services for associate companies forming part of the Expresso group in the UAE or elsewhere. So it's not in the UAE. In the UAE or elsewhere, which means even not anywhere, elsewhere, which is anything except UAE.
Yeah.
Another part regarding the time when the relocation is due, it's agreement when it was signed, actually in 2008, and at that time the assignment of Sudan didn't come actually, because the assignment of Sudan was in 2009 and the agreement was in 2008. So the relocation is for the movement from Sudan to join the company in Dubai in 2008. And the same figure which has been stated in the...
But then he said it's not a big deal to argue about this because you have taken the reallocation from your new particular claim. Is that right?
No.
Are you still claiming relocation?
Yes, actually, from the day one, it's part of the particulars of claim.
I think Mr. Hussein says you're not anymore claiming for the relocation.
No, we never change the claims. It's the same. The amendment we have done.
Yes, Mr. Hussein? You didn't say that. Maybe I took, yeah.
We didn't change that. We didn't drop it.
Yes.
And actually, it has been consistent. And even initially, they never denied it.
Yeah.
So we just kept that as part.
And he's saying that in your opinion, it's allocation from Sudan to Dubai.
Absolutely.
From
And
the mother company to the subsidiary.
not from the mother company. At that time, I was not working even for the mother company. In 2008, when I joined Expresso for the first time, I was not working for Sudatel. I had no relation with Sudatel, the parent company, or so on.
Oh, I see.
I was working for Zen, which is a totally different company.
Yeah.
And the company practice that all the international expats used to come from outside the UAE, they used to get relocation because they need support to establish homes, furniture, and so on. And that was the main reason for settlement. So you get for payment, you get allowances, so it helps you to settle down because you surrender your own home, wherever you used to be, and so on. Another point, you mentioned that the company didn't cover all the air tickets. Actually, the air tickets I claim as part of the particulars of claim are related to the holiday tickets, which is not business trips. So what I mentioned, all the business trips, which I've shown in my statement, are business trips. What I requested is something else, which is my holiday tickets, according to the contract, that every year I should get holiday tickets. So there is no provision there. Regarding the employment law and the new law, I came to know that from my lawyer colleagues and the lawyers here, that the principle of law and the rule of law, that if there is any amendment made to a law, an existing law, then the previous law, the beneficial clauses actually in the previous law will continue and not be dropped by the new law. And whereas actually if there is non-beneficial provisions, they will not be carried out. So that's my understanding, my humble understanding. I'm not sure if it's right or not, and I seek the court guidance on that. So this is that's all with regard to the points raised recently. Thank you, Your Honor.
Thank you very much.
Just one point, if possible.
Yes, go.
The visa. He mentioned that the
You have only one visa, is it?
No, yeah, he said that they issued this visa to allow me to come for the meetings. Actually, I am a British citizen and I can enter the UAE without any visa for up to 1 month. So if I need to come for meetings, I don't have residence. And they know that.
But you're not allowed to do work, even if you're a British citizen without permit.
Of course, of course. Yes.
So how you used to come for work before 2012, then? Before the visa and before the visa that we have copy with?
Yeah, before actually, when I came in 2008, I came using my British passport, so I didn't need visa. And the company was supposed to issue me a visa, and they were like, when we need it, then we're going to issue it. And I never need it because I have been always traveling. I have never spent like continuously 1 month in the country. Like every month, every 3 weeks or 2 weeks, etc. we travel. And then when I go, in 2017, I got married. I needed to have my wife in my sponsorship. So I requested the company to issue the visa for me, and they issued that visa, which is actually part of my rights according to the contract.
Well, I understand this is not in the bleeding, but he said he's in an answer to your query about then never another visa other than that.
Well, this court already has all the points and the laws in front of it. Your Honor, just one small point. Even if you see the pleadings, in the pleadings, they have now increased the claim further without providing any evidence. Without
further?
The unpaid leaves have been increased by 27,000 dirhams.
Yeah, but the overall is less than before.
Then overall it should be more. I don't know why they are written less. That must be a typographical error. It's not possible to be less. the way the claim has been written, it's not possible.
Yeah, I've seen your comment. Yeah.
Yes, Your Honor. So that's is again without evidence. How can this point be taken?
Just a miscalculation, and we have highlighted that in the request of the.
It is true. It should be increased instead of decreased.
No, the calculation, the summation, there was a mistake in the summation. And when we have done the calculation, the summation, we found that the total amount is this.
Maybe you missed
So
out.
that item is increased, yes, but the total decreased.
The total still decreased?
Yes.
And no mistake in this?
No, this is the figure, this one is the correct figure. 1,141,000.
Well, he confirmed this is the correct one. He's not asking for more than this, Mr. Saxon.
Your Honor,
He should stick to his choice.
Your Honor, we go by the pleadings of the parties, and I did not know until this moment that he confirmed what was the correct position.
He's still confirming before you. What if this is, you can take an action. If the case go through, then you can say, okay, this is your limit. You cannot bring case more than this amount, for example. But if it didn't go through, so you have killed the case, and that's the end of it.
Regarding the cost of the case,
Didn't talk about cost?
I just want to say that.
That would be interesting.
Yeah, of course. If hopefully that we win the case, let's say, I'm not claiming any cost, by the way. And I like to confirm that I will not claim any cost against whatever work we have done, because my intention is only to get my right, nothing more, no more or less.
I think you should consult your lawyer before you say a statement like this.
Actually,
Because if you lose, the cost can be hundreds of thousands of dollars.
yeah.
It's not, I'm telling you, it's not the court of Sudan, it's not the court of Dubai even. The court of Dubai, yes, the advocacy fees can be 500 or 1,000. But in this court, it can go beyond your imagination. Yes, it can be millions sometimes.
I never expected that.
Now I say, you better take your advice. I understand you are litigant in person.
Okay.
You might be ignorant. This is a very huge doctrine of cost recovery. Did not exist in the civil law, most of the civil law country actually. And it is a bit of, it's considered a very complex case for a civil law lawyers usually.
Thank you, Your Honor, for
And sometimes it's granted on a contingency basis as well. So you can't say if the winning party says my fees was $300,000 and I have alerted you and the judge decided, you base it in that basis, can be paid. You can't negotiate it, can't be reassessed. This is how it's working here.
It's good to know that. Thank you, Your Honor. Thank you very much.
Well, maybe it's time to thank you all for your presence and your presentations as well. I think you have answered most of my questions and queries, and it's to be honest with you, I have not made my mind. It's not a straightforward case, and I would have to read it again, and I have to go through maybe the recording as well again before I made my mind. And there is another thing to do. I'm not going to decide this case straight away within 1 or 2 days. I might need to up to 2 to 3 weeks or 1 month probably, because I have another pending case as well. So to be honest with you, I'm not expecting to issue this before 1 month. But if I issue it before 1 month, I will let you know, for example. I don't think I will call you for another hearing. But you will have my judgment through email, or you'll be notified by the registry. Mr. Hussein, when I deliver my judgment, I will give you another short submission on cost, either way. So both of you can submit to me a short notice about cost after my judgment.
Thank you.
Another question?
The second application, Your Honor?
For both applications.
But today we only argued one application.
No, we argued both.
Your Honor actually didn't, because we had a different goal. We only argued, as I had told you earlier, that there are two applications.
Yeah, we have argued the amendment, and then we have argued the immediate judgment
Although we
application.
have substantially touched upon those points, which are there in the second application, but if...
Wait, I had your skeleton argument before me about the amendment, okay?
That's enough for me, Your Honor.
And then you had said what you want to say.
Your Honor, I argued the immediate judgment application, but I think my skeleton covers the particulars of claim.
I have received 2 skeletons from your side, Mr. Hussain.
We are satisfied in this.
And I have read them both, and I heard you, and I think you have covered
Thank you.
both of them.
Thank you.
Thank you very much.
Thank you very much.
All right.